item for delivery of order at number 23 bail application 2311 of 2024.
Petition dismissed.
I would like to mention for listing one IAS civil for 50% withdrawal on Monday, Lordship.
Please, Your Lordship. Your Lordship, I beg to mention for listing of an MSc appeal for admission. It has not yet been listed for admission, though the delay was condoned way back in the month of August, Your Lordship. So it may be listed on 3rd or 4th, any date, Your Lordship, please.
Court.
Oblige, Your Lordship.
May I please, Your Lordship? With the consent of the other side, Lordship, I beg to mention item number 1313. Matter may be taken after vacation, Lordship.
Mr.
UB Sharma.
UB Sharma, learned counsel for the appellant with consent from the other side, press for listing the matter after vacation. Prayer lot.
Highly obliged. May I please, Your Lordship? Lordship, I beg to mention item number 5, Lordship. Lordship, with the consent of the other side, Lordship, matter may be adjourned, Lordship. Matter may be fixed after vacation, Lordship.
Mr.
B. Borgohai, Lordship.
B. Borgohai, learned counsel for the petitioner with consent from the other side, press for listing the matter after vacation.
Lordship,
Prayer allowed. Till then, interim order pass earlier shall continue.
Master, please.
May I please, Your Lordship? My Lord, I beg to mention hearing item 12, my Lord.
12.
12, my Lord, it's an old matter, my Lord. We are not in touch with the petitioner from several years, my Lord. So some instruction is required. Can it be posted after the vacation, my Lord?
Mr. A.R. Bhuya, learned counsel for the petitioner, submits that the matter may be listed after vacation
One.
so as to enable him to obtain instruction from the petitioner, as he has a last contract with the petitioner since long. Here is accordingly allowed. Recessal is the matter immediately after reopening of the vacation.
Oblige.
I have filed one interlocutory application for modification of the order passed by this honorable court, whereby a stay order was granted against the order of the tribunal without there being any order for a deposit of any amount. So
When it was passed,
on 24/7.
24/7.
I recently filed.
Is there any statutory requirement? Though we usually ask them
Well,
to
it's equivalent to a money decree.
money decree.
At this point.
Okay.
On Monday. Oblige.
I beg to mention item number 11, my Lord.
Yes.
Respondent, my Lord. My senior Mr. P.K. Roy, my Lord. He has some personal difficulty. I say, I'm paying for adjournment, my Lord.
Who?
Mr. P.K. Roy.
My Lord,
P.K. Roy Chaudhary.
I'm appearing for the petitioner in this matter, my Lord. My friend has taken consent last night. He has some difficulties. He's saying that can it be posted after vacation, my Lord?
Okay. As agreed by learned advocates of both the parties, recessal is the matter immediately after reopening of the vacation.
I'm highly obliged, my Lord.
Lordship. For listing of hearing matter, Lordship, MSc appeal, Lordship. And 3-4 orders, Lordship, on 12/11/22, 24th, Lordship.
12/11.
12/11. Oblige.
May it please, Lordship. With due concern, I beg to mention item number 18 with 19. I am appearing for the respondents here.
18.
18 with 19.
Mr. Dr. Learned counsel for the respondent. With consent from the other side, press for listing the matter after vacation. Fair allowed.
Oblige.
May please, the Lordship. My Lord, matter is relating to my Lord, MSCT claim. It is filed as a civil revision petition, but related to MSC case, my Lord. May I pay for listing the matter immediately after reopening of the
May it please, Your Lordship. With due concern of the other side, I beg to mention item number 21 with 22. Lordship.
Your good name,
M. Kashyap, Your Lordship.
Mr. M. Kashyap, learned counsel for the
Sir, appellant, Your Lordship.
learned counsel appearing on behalf of Mr.
R.K. Bhuiyan, Your Lordship.
R.K. Bhuiyan, learned conducting counsel for the petitioner and appellant. Price for listing the matter after vacation.
Vacation, Your
Okay, here allowed.
Lordship.
For withdrawal, sorry, for admission item one.
It is, Your Lordship.
Yes.
So, my lord, may kindly see the order dated 3/6/24, my lord.
Hmm.
They were supposed to process the file of the petition. 3 weeks time was sought.
I have received instruction. Government has sanctioned the area salary.
Government has sanctioned
Government has sanctioned the area salary.
area
Petition,
salary.
yes.
This petition was filed for area salary.
Yes, my lord. This was suspended, my lord. After
What
the
was the amount?
amount, my lord? 3 lakh something, my lord.
Sanction amount is here 2,73,136.
Yes, my lord. But our Lord, I have to take instruction, my lord. If it is sanctioned and if the amount varies, my lord.
What is the amount as per your calculation?
My lord, may kindly come to page 24, my lord, annexed 7, my lord.
20?
Page 24. This was sent by the district elementary education officer Gwalpara, who is
Hmm.
respondent number 3 to the director, my lord.
Hmm.
Here the amount was 3,12,847. It was sent by the one of the respondent only, my lord. And thereafter, my lord,
No, this is not the entitled amount.
yes, my lord.
This is only the budget amount he has asked for.
Yes, my lord. And thereafter, my lord, may kindly come to page 29, my lord. Page 29.
Hmm. So, Mr. Peko, why there is difference?
That instruction is not original. That instruction is not.
No, you have to come with the instruction.
Yes, but
My lord, I will also obtain instruction, my lord, in this
Hmm.
regard.
Okay, let us fix it on Monday.
Yes, my lord.
For Mr. SB, NBP Singha, learned counsel for the petitioner, and Mr. Pegu, learned counsel for the respondent number. One, two, and three,
one,
and 4, 5.
yes, ma'am. Elementary. 1, 2, 3.
1, 2, 3. None appears for the respondent number 4 and 5. Mr. Pegu, learned standing counsel for the respondent number 1, 2, 3, has produced a letter of the Deputy Secretary to the Gautabasa Department of School Education dated 23rd-9/2024. And apprise this court that a sum of rupees 2,73,136 rupees is sanctioned for payment of arrear salary in respect of the present petitioner. Mr. Sinha, learned counsel for the petitioner, submits that he may be granted some time to obtain necessary instruction in this regard, as the claim amount was in rate petition, in the petition where you have mentioned the amount.
Not in the prayer, my lord. At page 12, my lord.
Keep on line. Last word.
The claim amount
Was 3,66,891 rupees in the rate petition, and a sum of rupees only 2,73,136 rupees has been sanctioned. Mr. Pegu also submits that he may be granted some time to obtain necessary instruction why the amount sanctioned is less the amount claimed by the petitioner in the writ petition. Period is accordingly allowed. Recessal is the matter on Monday.
Malik, can you on Tuesday?
Tuesday. Okay.
oblige, my lord.
The letter produced before the court by Mr. Pegu today shall be part of the record.
Oblige.
Item 2.
Wait, please, it's a loss in my life.
Hmm.
Like, today we have some personal difficulties, madam. Kindly let the matter may come immediately after vacation.
In the earlier occasion, my learned friend, my lord, took time to, my lord, obtain the records of the estate officer. Matter relates to the eviction from the railway end. The earlier occasion, my lord, this honorable court directed to place the records pertaining to the, so far the records of the, my lord, lower court that has been filmed. But the record of the estate officer is in the railway that has been returned. That was supposed to be obtained in the last occasion, whether that record is received or not.
Sometime maybe my lord required to.
Or your lordship may kindly admit this matter and fix for hearing in the immediately after my lord vacation.
No, we'll try to dispose of the petition at the time of admission. Is this?
That can be done.
Heard Mr. D.K. Sharma, learned counsel for the petitioner, and Mr.
TSP Gwala on behalf of
S.P.
Mr.
Gola, learned counsel appearing on behalf of Mr.
DK Das.
D.K. Das, learned counsel for the respondent. Mr. Gola submits that Mr. D.K. Das, learned counsel for the inconvenience today, and therefore price for listing the matter after vacation. There is accordingly allowed. Recessal is the matter after vacation. And on that day, the learned counsel for the respondent shall produce the record
State officer.
of the state officer NF Railway as directed by this court by order dated
18/6.
18/6/2024.
Obliging.
Item 3.
My lord, in this matter, I have received instruction, my lord, kindly grant some time. I'll let you know.
Heard Mr.
GP. Take a vote.
A. Deka, learned counsel for the petitioner, and Mr. Pego, learned standing counsel for the respondent number.
Education department, preliminary education department. So 1 to 7.
Respondent number 1 to 7.
It is assessed.
Lordship, I am appearing for SSA on behalf of Mr. P. Naik.
1 to 7. And madam, good
A.
name.
Borthakur. A. Borthakur appearing on behalf of Mr. P. Naik for SSA.
A. Borthakur, learned counsel appearing on behalf of Mr.
P. Naik.
P. Nayak, learned standing counsel for the respondent number 8. Mr. Pegu, learned counsel for the standing counsel for the respondent number 1 to 7, submits that he has received instruction written instruction and he may be granted to file, granted some time to file affidavit in opposition. Here is accordingly allowed. Recusal leaves the matter immediately after reopening of the petition.
Date may be fixed. Otherwise, date may be fixed.
Date,
After vacation, any day, Lord.
date at a date.
On fifth, on 6th November,
So, apply.
item 4, bail hearing.
Apply.
I'm sorry, Malak, CD not received. Actually, Malak, my colleague wrote the date as 27/9. So we have called the CD today. Maybe fixed tomorrow, Malak. If not, Malak, then Malak, he by mistake, I have checked the record also. It is written as 26, Malak. Tomorrow.
Mr. A.M. Ahmed, learned counsel for the applicant, and Mr. Parasar, learned additional counsel for the state respondent. Mr. Parasar submits that he has not received his diary and pressed for listing the matter tomorrow. Clear a lot. Yes, so list the matter tomorrow.
Oblige.
Item 6, letter for orders.
No, please, your lordship.
Hmm.
Lordship, I have filed an interlocutory application in WBC 385624,
Hmm.
praying for implement of respondent number 6, the director of pension, in the instant WBC lordship. As the director of pension was inadvertently, it was left out in the area of parties. So since they are necessary parties.
Mr. Pego, who is appearing in this case?
Vacation of your second time, even. Can you ask about what time being?
Lordship.
Item 24,
May it please the Lord.
Hmm.
My lord, in this case, I am respondent in the second appeal, my lord. Sole respondent. And I have filed a petition with IN number 2561/2024, my lord.
Hmm.
Under Order 39, Rule 1 and 2, read with Section 151 CPC, my lord, for granting temporary injunction. Because, my lord, at this stage in the appeal, second appeal stage, my lord, during the pendency of this second appeal, my lord, the respondent, the appellant are constructing the house, my lord. And my lord, construction was started in July, my lord. In July, 16th July 2024. And I have objected not to make any construction during the pendency of this appeal, my lord, because I was the plaintiff originally in this case, my lord. Plaintiff, I have filed title suit number 57/2000 57/2000, my lord, 2010, my lord. And praying for specific performance of contract, because there is a contract between the plaintiff and the defendant. Defendant has took loan, they entered into an agreement with the plaintiff, my lord, to sell his plot of land. And accordingly, my lord, he took advance money, my lord, about 95,000. And with the condition that he will return with the stipulated time, but he failed to.
Mr.
You-
Bhagote,
Lordship.
have you filed objection here?
Lordship, we have already filed. That is already on record.
My lord, now the trial court
Hmm.
has decreed the suit in favor of the plaintiff, and on being appealed by the defendant, that was dismissed, my lord.
Hmm.
So there is a concurrent finding in favor of the plaintiff, my lord.
Hmm.
And the second appeal filed, my lord, by the
Okay, all right.
defendant.
Mr. Bhagote,
Lordship.
what is your objection?
Lordship, first of all, it is a specific performance of contract. Now appeal, second appeal has been already admitted.
Mm,
Both the judgments passed by the London School Lord courts below has been stayed.
mm,
Immediately we are that appellants, the respondent is the residing in the eastern side of our boundary. And we have been residing there, constructing all our whole construction is there. We have only repaired. I repaired because of their, like, you have spent.
Mr. Day, let him complete. Mm,
We have only carried out certain repair as because they have constructed new things, then their entire water comes into our plot of land. If it completely it has become flooding, we are not able to stay there. The old person, old lady is there, and one physically handicapped girl is there. So they are not able to stay. I can show certain photographs of it, where it clearly shows that rainwater is flowing into the plot of land. We have only raised that foundation so that at least we are able to stay. Now, in case that appeal is allowed, or otherwise, then in that case there is no problem. In case appeal is reversed, then in that case we have to give a position. Now let us come to the plaint. In the plaint, they have not stated anything that only the plot of land, the house construction they have not stated. That is not one thing. Because now they are raising that we have only newly this is not a new construction. We have only repaired the things. And repair there is no bar. The judgment has been stayed. In the event appeal is dismissed, we'll have to give them. And recently Supreme Court judgment has given. It is not a sale or sell that agreement. Sale agreement was not a this one absolute sale agreement. It was only that he took money for the purpose of medical treatment. In the event he is not able to pay that amount within a period, then it will go for sale. Supreme Court has said when the case of a defendant plaintiff is in an advantageous position, it is not supposed to be so and so. Advantageous position, he took the loan. Now subsequently we in our plate, the players we pleaded, yes, we are in a position to repay the amount. That London courts fellows would have first explored that option. In the event he is not able to pay that amount, then only it will go for. It is not that only thing that it was an absolute sale agreement. It is not an absolute sale agreement. It was clearly speaking.
No, Mr. Bhagwate, we are not married of the case now.
All right. What is that?
Now, you see, this appeal is pending at the stage of hearing.
Yeah, Lordship.
So in that case, how can you construct, start new construction
No,
here?
we have not constructed.
New construction, my lord, earlier
It is
there,
not new
I have given the
construction.
photograph.
Only we have
I have
carried
given
out
the
repair.
photographs.
We have carried out only repair works, and repair works is there. At this stage, even we can give an undertaking also.
On
If in that
concrete
case,
foundation is
we
given.
can undertake.
Thereafter,
Even the schedule of the sale, schedule land has not spoke about anything about the construction.
Hmm.
See, let us come to the sir, main appeal. In the appeal,
No,
What-
Mr. Bhagwate, you show the photographs to Mr. Day.
I have no.
My lord, I have annexed
I have
two
only
photographs in my
got it.
petition.
Yesterday I got it. I'll give it. Let the matter come tomorrow. I'll bring that photo.
And the information is that when I filed this petition, my lord, there is the one room only, tin roofed, pakka concrete foundation. Now they have completed 4 rooms, my lord. The latest position is.
We have only.
Construction is going on, some finished work
We are-
is remains.
We are
my
going
lord.
to, well, give undertaking, we are not going to go to get any construction anymore. It is already constructed and they have filed a petition only when we have filed our substitution petition. Our people have been already substituted now.
Hmm.
That not before that. They did not come before this honorable court because they were waiting that in case that appeal abates, there is no question of doing so. Now, when we filed our substitution petition, that was substituted with limitation petition also. That court, this court, honorable court considered our prayer, and ultimately we were substituted. Thereafter, they have filed that injunction petitions. So
Hmm.
my
So the
submission is there. We have
construction when
only,
starts, we
carried
have
out
lodged
repair
an
works.
FIR, no action, then I've come to
Right,
before this
repair-
honorable court.
After all, it is only a case of where it is a specific performance of contract, nothing more than that. And let us let us see that schedule. Schedule, they did not say anything. Where we have been living there, they did not deny that we did not live there. We have been living there. Let us live in the place where rainwater comes.
Earlier it was an Assam type dilapidated, Assam
also
type
still
house,
Assam type only.
Assam type house. Now they have constructed the concrete, brick walls, foundation and.
That means it is agreed
I
that
have
we have
given
been
the
living there.
photograph.
We have been living the Assam type house.
Can it be repaired? Can it be repaired? Can say that it is repairing? They have constructed new construction, my lord.
I am saying that
Okay, let us fix it tomorrow. In the meantime, both
we'll
sides
give the
furnish
photographs.
the
We'll show
photographs.
that there is rainwater is, there is latrine is total damaged condition. We are not able to do it. It is in the interest
Mr.
of.
Mr. Day, you also produce the colored photographs
All right, my lord, my lord.
tomorrow, as agreed by learned advocates of both the parties. This is a link for tomorrow. So as to enable learned advocates of both the parties to produce respective photographs of their respective no, photographs of the newly constructed, allegedly newly constructed house in the Suitland
And we'll like other areas also where the.
and also of other areas of the Suitland.
All right, sir.
Items for hearing, item 7. Pardon matter.
So chief, matter will be argued by advocate U.C. Rabha. He is coming, just he has arrived in the bar for a moment.
Last occasion, I had already made my submissions. My arguments are concluded, my lord. I was instructed, directed by your lordship to furnish a written argument in the matter, my lord.
Okay, you furnish to the court, master.
Item 8. Eight is the lordship. My lord, here in this case, my lord, the issue involved is with regard to rate of interest only, my lord.
Rate of interest,
Rate of
yes.
interest. Now, my lord, I have gone through a document of the plaintiff, my lord. In the, as per the agreement, my lord, there is a clause which says, my lord, in any event, if the construction could not be completed within time, my lord, then the rate will be as per the prevailing bank rate, my lord. Lordship may see the LCR, my lord, page 122, my lord.
Page number
Page number 122, CL number is marked, my lord, in the LCR.
122.
122 of the LCR. CL number is marked, my lord, in the above.
122 serial number.
Then clause will be F, my lord.
You read the clause.
My lord, the developer will complete the project within 3 years from the date of commencement of construction of the project and hand over possession of the land owner's share to the consideration within 3 years from the date of commencement of the construction of the project. In the event of failure of the developer to do so, the developer will compensate the landowner with a scheduled bank rate of interest on the outstanding consideration. Therefore, my lord, agreement was there. In any event, if the developer fails, my lord,
So what was the interest of the bank at the relevant point of time?
my lord, it was around 9%, my lord. I've given the chart. Different tables, my rates were given, my lord, here.
So when the construction was started?
My lord. The agreement was entered in 2005, my lord.
2005.
The agreement was entered.
So what was the rate of interest in the year 2005?
Perhaps it was 9, somewhat 9, I think. I have just got one copy.
This cert is up to 2010 only.
Sorry.
So up to 9% you are agreeable.
Up to 9, I'm agreeable, madam. And on the last.
Yes,
one,
madam.
My lord, this clause is there, clause F, which my learned friend has read. If my lord turns to internal page number 22,
Page number?
my lord, the internal page number is 22, my lord, on the LCR. My lord, if there was any default in payment,
Page number 22, yes.
My lord, the specification is given type A, type B. Not below that, the project being a time-bound project, my lord, interest will be charged for default in payment at the rate of 24% per annum, my lord. My lord, in case the default is made by us, my lord, we'll be levied 24%, my lord. In case they fail to deliver, my lord, it is the banking rate of interest, my lord.
No, what is this page number 22?
My lord, this is part of the agreement, my lord, which my lord friend has read. The agreement which was entered to between the appellant and the respondent, my lord. The development agreement which was entered on the 7th of November 2005, my lord. One-sided, if I may humbly submit, my lord. The wondrous, my lord, clause, one-sided, my lord. If in
Which
case,
one?
my lord, the fact that in case the default is made by us in payment, then we will be charged interest at the rate of 24%, my lord. However, if the developer fails to hand over the completed constructed flat to us within 3 years, my lord, then they will be levied interest only at the rate of 6%, my lord. The trial court is rightly awarded interest at the rate of 16%, my lord. Keeping in mind the inflation, my lord, there are various Supreme Court judgments, my lord. And in fact, my lord, if my lord goes to section 34 of the Code of Civil Procedure, if I may read, my lord, where and in so far as decrees for the payment of money, the court may, in the decree, order interest at such rate as the court deems reasonable to be paid on the principal sum adjudged from the date of the suit to the date of the decree. In addition to any interest adjudged on such principal sum for any period prior to the institution of the suit, with further interest at rate not exceeding 6% per annum as the court deems reasonable on such principal sum from the date of the decree to the date of payment or to such earlier date as the court thinks fit, provided that where the liability in relation to the sums so adjudged had arisen out of a commercial transaction, my lord. Ours is a commercial transaction, my lord, because there was an agreement which was executed between the appellant and the respondent. The rate of such further interest may exceed 6% per annum, but shall not exceed the contractual rate of interest, or where there is no contractual rate, the rate at which monies are lent or advanced by nationalized banks in relation to commercial transactions, my lord. So, my lord, the proviso clearly states that the rate of interest shall not exceed the contractual rate of interest. Now, my learned friend has very well pointed out clause F, where it is stated that the interest will be levied at the banking rate of interest, my lord. However, my lord, if my lord turns to page number 22, which I just pointed out, my lord. Here, the contractual rate of interest is 24%, my lord.
No, now the question is whether this page number 22 is a part of the agreement or not.
Because my lord, in the last occasion, I had submitted one judgment, my lord. Messrs. Ashoka Investment, my lord.
No, you first tell me whether page number 22 is a part of the agreement or not.
It is a document which has been issued by the developer, my lord. My lord, Meghamalar Estates and Services, my lord, this document has been issued by them, my lord.
Maybe, but whether this document was part of the agreement or not.
My per se, this document is not a part of the agreement, my lord,
Then,
but this document has been issued by them, by the developer, my lord.
maybe if it is not part of the agreement, how can you enforce it?
That is the reason why they have not paid for 25% interest in the plank, my lord. Since this is not a part of agreement, I think Lordship will see their prayer in the plank, my lord. They have not sought for 24%, my lord. Had this been the part of the agreement, they would have surely paid for 24% interest, my lord. In the plank, my lord, they have sought for 18%. What we will find the plank, my lord.
It is at page number 8, my lord, of the appeal memo.
The prayer is at, my lord, page number 18 of the appeal memo.
The prayer was made for 18%, the learned trial court awarded 16% per annum, my lord.
Now, my lord, this, as per proviso section 34, my lord, it should be as per the agreement of the clause, my lord. The agreement of clause says, my lord, at the banking prevailing rate, my lord. Therefore, trial court was wrong in awarding 16%, and my lord, trial court has not given any finding why he has given 16%, my lord. There is no finding at all, my lord.
The plaintiff is at
Start-
page number
8, my lord, it starts at page number 8 of the appeal memo.
My lord, the prayer portion is at page number 18.
18, yes.
18, my lord, yes.
So here the pair is for 18%.
18%,
Yes, my
because
lord.
since it was well known to them, my 24% will not be applicable. That's why they have paid for 18%, my lord. And as per the agreement clause, it is the prevailing bank rate, my lord. The prevailing bank rate was never, my lord, 16 or 18%, my lord.
Where is the judgment of appellate court?
And it's a judgment trial court, my
Oh,
lord.
this
the
is,
first
okay,
appeal.
this is first appeal, yes.
Starts from, my lord, page 25 of appeal memo, my lord.
Yes, yes.
Issue number 9, paragraph number 9, my lord, page 31, my lord. Is with regard to the issue of, my lord, awarding interest.
So, where is the cert for bank interest at the relevant point of time?
Allow me some time, I will just bring, take about 2 hours. Just find out from them.
Okay, we'll dispose of the matter today.
My lord,
You produce the relevant cert.
my lord.
And we will not call the matter again.
My lord, I'll just finish the chart, my lord.
Okay. If you have anything to submit, you can submit it to court master.
Mm.
And that judgment which you have referred to is not available in the record. You submit it to the court master.
Oblige, your lordship.
What is number 9?
Timing
Timing item 7.
written somewhere.
Yes.
Last occasion, my lord, I had already concluded my part.
Mhm.
It has been kept as part, and now
Mhm.
today is the duty of my learned senior to respond. My lord. I have already submitted my written arguments. Whatever I have submitted,
Have you furnished a copy to him?
yeah, I'll furnish.
Yes.
May I please, Lordship?
Mm.
This is the first appeal.
Mm.
First appeal. So, under six order 41. Rule 2 of the 41 says, ground on which may be taken in appeal. Here, Lordship, the law says, the appellant shall not accept by leave of the court, ask or be heard in support of any grounds of objection not set forth in the memorandum of appeal. But the appellate court in deciding the appeal shall not be confined to the grounds of objection set forth in the memorandum of appeal or taken by leave of the court under this order. So the law is specified there. Only they can ask on the grounds that has been included in their appeal memo. But here we have heard the other day, my learned friend has submitted some more grounds, new grounds regarding some payment of the amount. So the honorable court will only confine to the grounds that has been mentioned in the appeal of memo. Now, as far as the court, the main title suit is concerned, it is a case for the payment of works done, payments of work done. In the original TS, we have claimed the amount on the basis of accounts of statement of account. And we have submitted as many as 7. And we have also exhibited all the statement accounts on the basis of which our amount of claim is relied on. The other day, my friend stressed up to 2 points. One is the notice issued under section 80 CPC. One was given only in that matter. Both the notices, first and the remainder, the second notice, it relates to the other cases. Because as a background, the present respondent along with other contractor, they filed a move before earlier for the works of jointly done, they moved before this honorable court. In a repetition, in the civil order number 5253/96. That was in that case, there was some wrong, as per the plaintiffs, there was some mistakenly, inadvertently, the amount was written as 14 lakh something else. And clarified as a reminder, they issued a second notice that it should be 18 lakh and some odds. That was the part of the, as far as notice issued upon HCBC is concerned. So that notices, so far that notices is concerned, this is a particular specific case, there is no connection, no relation at all. It is a separate case of the plaintiff. So that they have done no connection. Only the remedy is that the only statement accounts for accounts, whatever there is, that we have basic, our basic claim is on the basis of the statement accounts. That is the basis, conditional basis of the claim of the petitioner, the plaintiff. The lordship on basic point is that when you look to the main suit, plaintiff adduced two witnesses, the evidence of two witnesses, along with the documents, those we have exhibited. Only contrary, the contesting defendant, the relevant department, they adduced, they submitted only the evidence, only the written statement by the respondent number 5. And report will reveal that even then, though the respondent number, defendant number 5 submitted written statement, it appears to be an individual one, because he is submitted without any authority by the other defendants. And that is the main thing. What is then it comes to that they did not adduce any evidence.
No, that's all right, but it does not relieve you from establishing your case.
Yes.
You have to establish.
Yes. And that did not produce any and examine any defendant witnesses.
That's all right. All right.
And except and
Now tell me whether the claim amount is a proof from the documents furnished by you or not. So your claim is that you are entitled to a sum of rupees 51,34,336 rupees.
Yes.
So whether from the documents furnished by you and exhibited by you and proved by you, establish your claim or not?
Our claim is on the basis of the statements of account. That amount to 51,034 lakh and something else. Statements accounts have been exhibited.
You show the accounts.
I've given the details in the written argument.
Let him. I'm not asking you.
No, I'm sorry. I apologize.
But their case, even in the case, is that accept and say will accept the written statement filed by the division number 5, they did not file any documents. But the law is very clear. It is mandatory because order 10, rule 1A says duty of defendants to produce documents upon which relief is claimed or relied upon by him. It is the mandatory.
No, that's all right. That is a settled position.
That is not compliant. No document is.
That's all right. Since he has not adduced any evidence, any documents exhibited by him, so we cannot rely upon the WS filed by him.
Yes.
So forget about WS. Now, whether from the documents you have exhibited, it can be said that you are entitled to a sum of rupees 51,34,336 or not.
That's it. So it will depend on the statement accounts,
Hmm.
but they have
Yes.
not denied it.
You saw the statement of accounts. You saw the documents.
This is the law. In support of that, the Supreme Court also has a set guideline, rather it is a precedent that in a classic case, is a Bidder.
Hmm.
Here, the Supreme Court has observed inter alia that where a party to the suit does not appear in the witness box, here also did not examine any witness, and instead his own case on oath and does not offer himself to be cross-examined by the other side, a presumption would arise that the case set up by him is not correct, as has been held in series of decisions by various high courts and privy councils, beginning from the decision in Soda Rubens and Sassansa. This is the Supreme Court order, and plethora of cases of the High Court also observe that the under section 114 of the Evidence Act, it court can presume that non-examination of any witness to support their case will with inference that they have no case. This is one of the classic case. So here too, Lordship, they simply submitted a written statement, no witness is there, and none appear in witness box. So it clears that though they contested the case, but they failed legally to counter our claim, and they did fail to prove their case, prove their claim that this is a position. And further, the findings of the trial court appears that there is no irregularities or infirmities as regards judgment is concerned. And they have also had to assert on that point that if there is any irregularities or any wrong or any, so to speak, any perversity, so therefore our humble submission is to interfere with the judgment of the trial court. Is this sum up? Yes. Mhm.
Page number 6 in the memo.
Page number 6, 7, 8, then 9, 10, and 11, 12. Then he stated the grounds. Number 1. According to the appellant, the judgment and the decree passed by the trial court is not a judgment and decree. That is ground number 1. Now, what is this? Number 2, they have raised the point of jurisdiction. They stated that the suit ought to have been preferred at Tinsukia. According to them, the entire contract was stated to be entered and allegedly performed in district of Tinsukia and not at Dibrugarh. But record shows that some of the contracts were signed at Dibrugarh and some of at Tinsukia. As because the divisional railway manager office is at Tinsukia and Dibrugarh is under DRM of Tinsukia. That is why this is one office. Number 2, they have raised the point of arbitration. So far, point of arbitration and the jurisdiction, those are already decided by the trial court, and they did not prefer any appeal. Of course, they preferred a revision before this Honorable High Court against the order passed in arbitration matter, but that was also rejected. So both the points are this is finality. Now, so far, other points they have raised are concerned. They have categorically admitted that some amount is due to the respondent, plaintiff, but they have disputed the correctness of the amount. It is clearly they have admitted, and in their copy of written argument they have filed before Lordship, it's also furnished, just furnished, and I have gone through, not thoroughly, but gone supervision. And therefrom, it is also appeared at the page number 7, Lordship, of their written argument. Based on above calculation, the actual amount due, including security deposit in connection with 9 numbers of contract works, comes to an amount of rupees 16,88,510. And the interest part of the actual dues and security deposit calculated at the rate of 18%. 18% is calculated by the respondent himself, of course. It is a question to be determined by the Lordship. Comes to an amount of rupees 24,48,909. It is their admitted position. Sum total of the actual alleged dues and interest combined comes to an amount of rupees. It is they have admitted 41,57,419. It is not my part. So for other parts, it is to be decided by the Lordship after going through the record and evidence. Now, so far, it is admitted they have only preferred presented their written statement, but the plea taken in the written statement are not.
No, I have already told you
Yeah.
that forget about written
Yeah,
statement.
Lordship.
Whether from your documents you have been
Yes,
established to,
Yeah.
you have been able to establish that
Lord.
you are entitled
Yeah.
to a sum of rupees
Yes.
51 lakhs.
Lordship. Now, the plaintiff, in his evidence, produced both oral and documentary evidence, and in exhibit 2, 3, 4, 5, 6, 7, 8, 9, these are the statement of accounts the plaintiff has submitted before the trial court, and the defendant was given opportunity to cross-examine on those parts. In that statement of the accounts, he has fully disclosed what amount is due and how he has calculated. Now, Lordship, another point is there, exhibit 10.
That is a completion certificate issued by the railway department, railway authority, not by. And herein, it is a certificate for completion of 5 works. Altogether 9 contractors are given, and out of 9, they have given 5 completion certificate for 5 works, which is exhibit 10. And so for other 2 works, they have completed, and bills were prepared, and the measurement books were prepared, but they have not produced the measurement book before the trial. Then for the remaining 2 works, that means 9, 8 and 9. Then for 2 remaining works, the plaintiff has completed 15% of the works out of total. And while completed 15%, they have already given a certificate. Thereafter, the ghost conversion works was started by the railway department. And the railway authority themselves stopped the work after completion of 15% works. Now, my material question, one question, my submission is that during trial, while they were afforded opportunity to cross-examine the PW, particularly the plaintiff, it is apparent that they have not crossed effectively. They have not crossed as per their plea. They have put certain suggestions, but suggestions cannot be considered as evidence or which are denied by the plaintiff himself. So on the order 18, rule 1 and 4, the defendant is to prove his case. I have proved, and in a civil matter, preponderance of evidence is sufficient. But they have adduced no evidence, and therefore, I-tendered evidence are allowed to cross, but they only put certain suggestions. So these are the matters to be considered by the Lordship. As per section 102 of the Evidence Act, they have also duty to prove their own case.
I will not trouble your lordship with further arguments, my lord. Only to give a clarification with regard to my written argument, my lord. My learned brother referred to page 7 of my written argument. Based on those statements, he is trying to suggest.
This amount you have agreed.
No, definitely. What I'm stating in this paragraph is that based on their statement, these are the calculations, and even assuming it to be true, it could not have been 51 lakhs. It's their calculation. Based on the table, these figures comes out, my lord. It's not an admission, my lord. If lordship reads the written argument in a holistic manner, everything will be discernible, my lord. This is not an admission. I have given the table where they have stated that these are the statements of accounts, and based on the statements of account, my lord, these are the figures which comes out. That is what I have stated. This is not an admission on my part. Based on the statements of account exhibited as exhibit number 1 to 9, these are the figures that comes out, and even assuming it to be true, it cannot be 51 lakhs. That is what I have stated in this paragraph, my lord. It's not an admission. The written argument is exhaustive, my lord. I have not adduced any evidence, my lord. That's why I cannot rely on my written statement. Agreed, my lord. I am not disputing those facts. And so far as the technical arguments are concerned with regard to limitation, arbitration, and the other territorial jurisdiction, I leave it to your lordship, my lord. Whatever lordship decides, I'll be satisfied. But so far as the decree for recovery is concerned, these are, my lord, contractual dues. These amounts have to be proved by documents, my lord. Documents have to prove this announcement, and that they have miserably failed. That's my suggestion.
We have already exhibited, and they were afforded opportunity to cross on those documents.
It's their duty to prove their case. They cannot rely on the witnesses of
That's to
the.
be looked into my lordship.
That's the submission.
Yeah, heard Mr.
B Sharma.
D.
B for
B.
Bangalore.
D. Sharma,
Sharma.
learned counsel for the appellant. And also heard Mr. U.C. Rava, learned counsel for the respondent. Argument concluded, order reserved.
Not sure. Not sure. Item 8.
I just wanted to point out one thing, my lord. Here in the judgment, my lord, that interest was awarded from 2010, my lord.
Hmm.
See, from the rate of interest of 2010, I have already provided, my lord. Obliging.
Item 9.
With the lordship,
Hmm.
lordship, on the last occasion, the matter was fixed at 2 for today,
Two,
at 2
today.
today.
Okay.
Organized.
Item number 10.
My lord, another 15 days time is required, my lord. It is our mortgage process is almost, my lord, going to be, my lord, completed. So, my lord, and another aspect, my lord, arguing counsel Mr. B.D. Goswami, his mother-in-law is admitted in name care hospital in critical condition, my lord. So, may I pay only 15 days, my lord?
Oh, on the other day, Mr. Bhuya has rightly pointed out
Yes,
that,
I admit, my
you
lord.
will come with
Still, my lord,
similar
the process is going to be, my lord, my lord, it is completed within 15 days. So, my lord, only 15 days time, my lord, honestly, my lord,
Hmm?
as a mercy, my lord, lordship may grant under 15 days time, my lord. And they are getting entire money, my lord, during the puja, my lord.
Lordship, this will continue.
Continue, I know, my lord. This is a government
That's
process, my
never-ending
lord.
business.
Mortgage lordship, it goes through a process, my lord. We have to, my lord, obtain the NOC from the administrative department. So, my lord, this process is delayed, my lord. My lord, as a mercy lordship may grant only 15 days
The
time.
last chance has
Now,
been given.
this is the last chance, my lord.
Last chance has
Lordship may
been given
record
by
my-
honorable
record
court. There
my
has been no
submission.
last chance.
Lordship may record my submission. It is almost, my lord, completed, my lord. Entire process is, my lord, under government administration. So, 15 days at least, my lord. More than 100 employees are working in the office, my lord.
But what is my condition?
They are also getting
They are thinking about their employees. I am not getting the rent since the month of 2019, Lordship. Last 2096 years has been gone. 5 years. I have not received a single penny from their 3,50,000 of rupees per month rent. I am not getting it. They are thinking about their employees. What is my condition? Fourth time last chance has been given
during
today.
puja, my lord, they will get entire, my lord, dues, my lord. There is assurance from my CEO.
They are not
from
going to pay the
CEO of
entire
the
balance
company.
amount.
No, no, my
If
lord.
the matter to be heard, finally, there's nothing to be heard, Lordship. They are admitting it, they are not paying the rent. Not a single penny they have deposited in the rent in court. They being a tenant. And they are not depositing the rent in court. They are not paying the admission, paying the rent to the landlord. What remains to be argued before this honorable court in the appeal? So they admitted their defaulter. Is their defaulter, the trial court judgment is to be upheld. And I will go for execution.
They knows very well that after next 15 days, it will be
My lord, my lord.
holiday.
Puja, definitely.
No, they don't, but within puja, my lord, they will get them.
After
And during, my lord,
September, there will be holiday.
lordship may fix it in the puja vacation.
Puja vacation.
No, vacation.
How the
code,
honorable
my
court
lord.
will take up the
Even,
civil
my lord.
matters?
Vacation code lordship may fix, my lord. Only 15
They are
days
so,
time, my
so special, Lordship.
Hmm?
They are so special.
Another
They
side,
don't have any
my lord,
fiction.
and arguing counsel also not present, my lord. Due to condition of his mother-in-law, my lord.
There is a apprehending that, your Lordship, I have on the earlier occasion, I submitted before your Lordship. This, they will come in again and file a petition for adjournment. And after 15 days, same will happen. Because I am fetching it.
Hmm.
if I have not paid, we have in the next day, lordship may direct, my lord, fix a date for eviction, my lord.
This is not executing court.
Not direct the executing
Tribunal
court, my
court is to
lord.
dismiss the
Lordship may direct.
Lordship, so is they may not
If your
be-
lordship dismiss it, then automatically
No,
execute.
stay may not be not allowed to be continued. That
Only
they have
15 days, my lord, I am paying.
Earlier stay is vacated, after.
Even, my lord, as per my instruction, my lord, yesterday, my lord, the CEO and the, my lord, landlord, both of them, my lord, have some discussions. That, my lord, my.
You do one thing, let your CEO remain present in the court at 2 p.m. today.
Lordship,
We'll only then we will consider.
my lord, my lord, my lord, my lord. Problem.
Item 14 to 16.
Your Lordship. Your Lordship, item number, Lordship, I have a small request, Lordship. In item number 16, Lordship, this is with regard to matter of terminal charges, Lordship. And this was filed in the year 2017. And Lordship, the counsel for the appellant, Railway Lordship, have relied upon the decision of this honorable court that is passed in MFA 100, which is very much relevant to this case. But that judgment was delivered after the filing of this case, Lordship. So that order was clearly discussed in this case, Lordship, in item number 16. So I humbly request, Lordship, if Lordship take the item number 16 as a first item, Lordship, because in that case, Lordship, the MFA 100 is detailed discussed in that order, Lordship. So it will be very much helpful for both of us, Lordship. If my senior counsel also agrees with me, so this can be taken up as a master file, Lordship. Item number 16. Your Lordship, I do not disagree with the saying what my learned friend she is saying that, but Your Lordship, chronologically, if I go, then later she may object to that point that these two particular petitions, like for 50, like item number 14 and 15, they do not, this judgment does not rely for both these cases, Your Lordship. So it will be a bit chronologically helpful for me in order to, it is for Lordship decide. May be taken as the item number 16 may be taken as a master file, Your Lordship, but can we just start with item number 14?
Okay, as per the list.
Yes, yes.
Item 14.
Yeah, yes. Your Lordship, item number 14 includes terminal charges as well as graded concession method. Item number 15 also terminal charge, graded concession method. And item number 16, it consists of terminal charges, Your Lordship. So I'll start with the item number 14, Your Lordship. So it's always the railway, the facts are very much important here, Your Lordship. So this appeal, Your Lordship, has been filed under section 23 of the railway claims. This appeal has been filed against the under section 23 of the Railway Claims Tribunal Act against the order and judgment dated 6/8/2015 passed by the Railway Claims Tribunal, Guwahati Bench in claim application OA 3/15 of 2009, Your Lordship. Your Lordship, before going into the details of the matter, I would like to refer to the judgment upon which we have come to before this honorable court, Your Lordship. So the judgment dated 6/8/2015, Your Lordship. Here, specifically the facts are being stated here, Your Lordship. So initially, I would like to say that the claim, it is regarding the award that the learned RCT has given, Your Lordship, is rupees 2,01,000. It has been given for the applicant, Your Lordship. So Your Lordship, I'd like to refer to the issues that those have been framed here in this judgment, Your Lordship. The issues are in page number 3 of the judgment. of the learned code below.
Mm.
So issue number 1 and 2, one is regarding the notice served under section, it is in para 5, Your Lordship, of the page number, page 3.
Yes.
Your Lordship, here issue number 1, 2, 3, 4, and 5. These are all in dispute, Your Lordship, but we are going to basically emphasis on issue number 3, 4, and 5, Your Lordship, which for which the grounds are mentioned here in the appeal, Your Lordship. The main issue is issue number 3, which says whether the respondent realized freight as per correct distance. And number 4 is whether the applicant is entitled for concession as alleged in this application. And number 5 is whether the respondent is entitled for terminal charges. Your Lordship, for the other 2 cases also, this terminal charge is a matter in 3 cases altogether, as well as the graded concession, which is also the matter of these other 2 cases, item number 15, Your Lordship, and in item number 16, only terminal charge. So, Your Lordship, here I would like to refer to the claim application that has been filed by the claimant here, Your Lordship.
That page number?
Your Lordship, the claim application is in page number 20 of LCR, Your Lordship. Here we have also submitted along with along with this appeal also, here it is.
Page number?
Page 39 of the memorandum. Actually, Lordship, different council had filed this petition, so it is a bit difficult for me even to go through the pages, Your Lordship. Page number 35.
35 or 38?
39, Lordship. 39. The brief which I have carried this.
39 is a form 1.
Your Lordship, maybe
Yes,
a
Lordship,
page.
this is the claim application.
The
Okay.
claim, the OA that had been filed before the learned RCT, Your Lordship.
Okay.
Here, the basic fact that the date of booking was on 9/2/2008 regarding RR number 212000980 to 21200000983. Here, 35,597 bags of salt were loaded, train loaded, and then the advocate claim letter was 16/4/2008 and 28/7/2008, Your Lordship. So initially in the court below, we have objected to the notice that those were being sent by the consigner, but later on we are not objecting here or taking much ground regarding this particular point, Your Lordship. Here, the fact of the case is that regarding the overcharge that they have mentioned, and they have mentioned in para 1 that that we are at the named consignee and paid all railway freight money to the railway via money receipt number 743789 dated 9/2/2008 at booking point, and also delivery taken by us on submission of
Which
original-
paragraph you were reading?
I am reading, Your Lordship, the fact of the case, para 7(1) of the claim petition.
1A, B, C, or which one?
Your Lordship, 1A.
Okay.
Yes, Your Lordship. Here they have mentioned that they have paid the freight money as well via this money receipt number such and such dated 9/2/2008 at the booking point. Booking point, Your Lordship, was the Haldwar, it's in Gujarat, and to Dikom, it is in the district of Dibrugarh in Assam. So regarding this, and by our submission of original RR at destination, they submitted the destination submitted the RR, the railway receipt. And as such, we hold all legal title in terms of section 74 of the Railway Act. We have been overcharged freight due to railway wrongs at booking point. So, Your Lordship, railway at booking point made serious calculation mistake in calculating the freight charging distance and rate and other charges, and as such, we have overcharged freight in this transaction. Number B, the railway collected freight on distance 3236 kilometers, but the correct freight charging distance by the shortest route will be 3181 kilometers.
Just a minute difference, your lordship. As per Railway Board Circular TCR 1125943 dated 6/10/1994, read with NF Railway Circular C374 RG1 Part 10 dated 21/11/94, which permit booking on the consignment by the shortest route and at the cheapest freight. Here, your lordship, the distance, the calculation of the distance they have made, according to them, the total distance should be 318077 kilometer. Rounded at 3181 kilometer, rate would be 1609 per 10 metric ton. So this is their claim, your lordship. Now, claim number C here, 7C, is that as per the Railway Board concession circular number such and such dated 30/4/2003 and 29/5/2006, the consignment booked over distance 3001 kilometer are entitled to get freight concession at 25% at the book time of booking, but railway at booking point made calculation mistake, and for this railway wrong we have been overcharged. So, your lordship, there is a slab there. I'll come to the circular. Railway has that slab that below 3,000 kilometers, they will get a concession of 20%, and above 3,001 kilometer, they will get 25% concession. So, there is also a calculation to be done in this regard, your lordship. So, they have claimed that we have not received the 25% concession. We have only received the 20% concession in this regard. The total, number D, that total 35,597 bags salt booked by from Haldwar to Decom, which are regular goods booking and delivery station known as goods shed. We respectfully point that the railway collection of originating terminal charge OTC on account of booking station HBD goods and also collection of destination terminal charge DTC on account of destination station Decom Guwahati, Decom goods, which we know as goods shed, managed and controlled by the railway for last several years, and these stations were never statutorily notified by railway as terminal stations, and as such railway collection of excess freight money on account of terminal charge at the time of booking is wrong, and we claim refund of the same. Your lordship, it is that they have interpreted that it is a goods shed. From times before, they have been hearing it as a goods shed, not as a terminal point or terminal shed or terminal station. So the terminal charges that have been levied by the railway are not appropriate. Number two, that as we know, in this transaction, the booking station is starting station and not terminal station, and as such, any imposition of so-called terminal charges for booking station do not fit in definition of the word terminal. And for this railway wrong, terminals collected on account of starting booking station is wrong, and we claim refund for the same. Number three, the total 35,597 bags salt booked in this transaction as per the Railway Board Circular such and such dated 29/5/2007, 17/7/2007, 18/9/2007, and 17/1/2008. The charges known as terminal charges are not at all applicable in this. Thus, collection of terminal charges by the booking station in this transaction is wrong, and we claim and demand for refund of the same. So here, your lordship, here and E, they have stated that the claim for refund of freight overcharge submitted by the railway through our advocate letter dated such and such, an amended letter dated such and such, the respondent disowned liability pleading on technical ground via railway letter dated 30/5/2008. The prayer for review of the railway decision such as 30/5/2008 with supporting document also submitted through an advocate letter that is such and such, but have not received any refund of money. So as per their claim, their calculation comes to 2,01,000. So this is what is their claim, your lordship. So now I'd like to refer to the judgment, your lordship, that has been delivered by the learned RCT here in this regard. So regarding all the issues, these have been settled on behalf of the applicant. So the reason those have been cited, I would like to refer to the issue number 1, your lordship, here in page number 16 of the appeal, your lordship.
Yes.
Your Lordship, issue number 1 says that paragraph number 8, the consignment was booked on 9/2/2008, notice dated 16/4/2008 under such and such. Your Lordship, it is regarding it, and they have said that they have settled regarding the applicant, and number 2 in favor of the applicant. So we are not disputing these two. Let us read issue number 3, Your Lordship, in paragraph number 12. As per the copy of the railway receipt, the distance for Halbad to Decom is 3236 kilometers, whereas as per the information received by Deputy Chief Claims Officer and Public Information Officer of the Western Railway under Right to Information Act via letter dated 28/8/2008, Exhibit A21, the distance from Halbad to Decom is 3177 kilometers. Besides, it also states that for 3177 kilometers, the freight chargeable rate is 1609.10 per metric ton. The above shows that the respondent has collected freight from the applicant on incorrect distance. So the particular conclude the on what ground the learned RCT has reached to this particular conclusion is not at all an appropriate adjudication of this particular matter, Your Lordship. That is our ground, which we have taken here, Your Lordship, in the ground. You'd like to refer to page number 8, Your Lordship, at paragraph number 5, Roman 5. Page 8, Your Lordship, at para 3. From here, you can start, Your Lordship. That for that the learned member have wrongly held that the appellant number 1 had made an admission in the letter dated 28/8/2008 RTI, and
You are
accordingly,
reading para
para 3, Your Lordship, of the appeal, page 8.
memo of appeal starts from yes, page number 1.
Your Lordship may turn over to the page where the grounds are mentioned, Your Lordship, at page number 7, then page number 8. Here, Your Lordship, it has been mentioned that for that the learned member have wrongly held that the appellant number 1 has made an admission in the letter dated 28/8/2008 RTI information. Accordingly, come to a conclusion that respondent is entitled to refund of the claim amount. However, the fact remains that the said letter was issued for estimate purpose only and has no relation with the alleged claim, and the Honorable Court, having failed to consider the said aspect of the matter, has caused miscarriage of justice, Your Lordship. So here regarding this, the letter dated 28/8/2008, which is exhibited as A21, Your Lordship, in the LCR. So it has been wrongly interpreted where the letter was issued for estimate purpose, Your Lordship. And only this particular RTI has only been taken in order to decide issue number 3, where it states that whether the respondent realized freight as per correct distance. So now how the distance has to be calculated, or why there was a mistake, or how this mistake has been there. So this particular
this distance was calculated on the basis of this RTA information.
No, Your Lordship. Railway had calculated and they have taken
No. This why this RTA information exhibit A21?
This information they have, as per the information they are furnished by
Who furnished this information?
Deputy Chief Claims Officer and Public Information Officer of the Western Railway. Letter. Your Lordship, I could not find this letter there in the LCR, Your Lordship. So So reaching on this particular, if my learned.
You
friend
check
can
it if available.
Yes, Your Lordship, I will say.
Will you come back after 5 minutes?
Okay.
Through video call because it is 5 hours journey, my lord.
It is in page number 50, 51, 49, 50 and 51, Your Lordship, in LCI. I flagged it in.
Yes.
Yes, Your Lordship, it is an RTI that has been answered. So, and here on page number, on the next page, Your Lordship, the estimate is there, Your Lordship. That the distance from Haldwar to Decom, here the at the end it is written 3177 kilometer. But Your Lordship, I would like to make a mention that, this is an estimate, this is for estimate purpose, it is written there on the heading.
Maybe,
Yes, Your Lordship.
but for different purposes, the distance may not be different. It may be the same. It should be the same.
Your Lordship, at the booking station, when they booked, they got 3236.
And this is the information furnished by you.
Yes, Your Lordship.
Then you want to dispute your own document.
Your Lordship, at the time, but here, Your Lordship, the claim that they are also claiming regarding the claim that the judgment, I'll come later on here regarding, Your Lordship, the issue number 4, it is very much important, Your Lordship, where concession regarding 6% of the any state and regarding circular of 7/8/2008 that has been given, Your Lordship, that has been allowed. But here, no mention in the claim application has been made regarding the 6%, Your Lordship. Though regarding this distance, Your Lordship, I cannot dispute that particular document, Your Lordship, but at the booking point, when they have calculated the distance, hopefully they have done it as per the railway board circulars, which I am going to come before Your Lordship. I am going to read on the circulars, Your Lordship. So here our stand is that I have made in the, we have taken a stand in here that it is regarding the estimate purpose which is being calculated and not on the factual distance that was there on the date of booking, Your Lordship. So, Your Lordship, regarding issue number 4, Your Lordship, that so I'd like to refer, I'd like to say, Your Lordship, here in this regard, this issue only on this particular document, the unlearned RCT has given the claim to the applicant and not referring not referring to any other circular, Your Lordship, of the railway board. So, Your Lordship, here in issue number 4, in the defenses have been taken in the through WS also by the respondent number 2 as well as respondent number 1. Respondent number 2 is the Western Railway, Your Lordship. So the booking was done there in the Western Railway zone, and now the destination, it was there in Assam. So 2 zones are included, so 2 respondents were there. So, Your Lordship, here issue number 4, in the information furnished by the Deputy Chief Claim Officer and the Public Information Officer of the Western Railway under RTI, Exhibit A21, it is clearly stated that the applicant is entitled for concession of 25% for the salt consignment as per Rate Circular 47/2006 and also 6% concession of the any state as per the Rate Circular number 7 of 2008. But which, by going through the claim application, there is nowhere mentioned regarding this 6% concession. Your Lordship, we do not deny the fact that if the kilometer is above 3001 kilometer, then the concession won't be 25%. But there is also a calculation, because that should not come below the roundup. If the total distance that comes up or the fare that is being calculated is comes to the, it goes to the other slab, which comes within the 20% slab, then again, they will be getting only 20% discount, your lordship, not the 25% of concession in this case. So that calculation is also being made, your lordship. We will have to refer to rate circular 4740 2006, your lordship.
Page number?
It's paid in page number 27, your lordship, of the appeal.
Yes.
Your lordship, this is a rate circular. It says that the levy of development surcharge and terminal charge sanction of the central government is hereby accorded to the levy of development surcharge on goods traffic, which will be 2% of normal tariff rate. Here it is paragraph number 2 says that the sanction of the central government also accorded to the levy of terminal
Paragraph
charge.
number 27.
No, your
No,
lordship,
page number 27.
yes, page number 27, rate circular 58.
No, this is 47,
Oh,
page number.
Yes, so lordship, I'm reading that only, rate circular 58. Maybe the paging is different.
No, not 58. It is rate circular 47 of 2006.
Okay. Take some time, your lordship. It may be enough.
You first arrange the documents.
Yes, yes,
You have relied upon.
yes, yes.
So we will start hearing after 2 p.m. then. In the meantime, you make necessary arrangement of the documents which you have relied upon. Yeah.
So your lordship, actually, this document, actually, we have not furnished the document, your lordship. And in this.
But anyway, it is your document.
Yes, your lordship.
You arrange the document first.
Item 17. Increases, my lord. I have filed my wakalatnama just today, my lord. Ideally, I would have sought for an accommodation. The difficulty, my friend, I reckon, has come from outside. I called up the local council. He had informed last night that he's come from outside. Otherwise, I would have required some accommodation, my lord. I've just been engaged, subject to what my friend said.
That's your lordship's pleasure. What can I do?
You are from
I'm from Calcutta.
Calcutta.
Yes, yes. Because we want that the matter should be hard as a contested one.
Yes.
So I also want that my friends should be ready to
Yes.
assist the learned code in all respect.
Definitely. So just the possibility of
Suggested date then
28th or 29th of October.
29th of October.
28, did you suggest?
28th.
28 is not Monday, 29th.
29 will be approved. Till the hearing day.
31st, 28th, 31st. Maybe holiday it is showing in the red color, it is holiday. 28th. Can it go to November? It will be convenient for me if it is done on October itself. Because at that time I have the holiday in Calcutta. So the
Acha.
High Court is opening on 4th of November.
Acha. Okay. 29th. Okay.
I'm grateful.
Okay. Okay. Right.
Item 20.
Kindly take up the matter after some time. My senior is on legs, Lordship. Obliged.
Timing item 6.
Fix your Lordship. Instructions awaited, your Lordship.
Oh, that's all right. She has filed one IA.
Yes, your
You
Lordship.
have received the copy.
Yes, your Lordship, I have received.
Any objection?
No, your Lordship.
Heard, miss, your good name, please. Pardon?
Gitanjali Dekha.
Gitanjali Dekha, learned counsel for the applicant. Then also heard Miss Teran P, learned counsel for the standing counsel for the respondent number
1, 2, and 4, your Lordship.
1, 2, and 4, and Mr.
A. Borua.
A. Borua,
On
learned
behalf of
counsel.
Mr. C. Borua. On behalf of Mr. C. Borua.
Appearing on behalf of Mr. C. Borua, learned standing counsel for
AG.
AG.
On number 3.
This interlocutory application is prepared by applicant Mohesh Chandra Das. The petitioner in a red petition number 3856 of 2024 for according approval to implement the Directorate of Pension Assam as respondent number 6 in the aforementioned red petition. The learned counsel for the applicant submits that due to inadvertence, the Director of Pension could not be made a party in the red petition, and in order to adjudicate the issue raised in the said red petition, implement of Directorate of Pension Assam is very much necessary, and therefore it is contended to allow the petition. Ms. Teran P, learned standing counsel for the respondent number so and so, submits that she has no objection in the event of allowing this application. Para, having heard the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, implement of Directorate of Pension Assam is found to be necessary here in this case, and accordingly it is provided that the Directorate of Pension be implemented as respondent number 6 in the red petition number so and so so and so. In terms of this, I dispose of the petitioner in red petition number so and so shall take step to issue notice to the newly implemented respondent and also file amended cause title within a period of 1 week from today. Step be taken by registered post with AD and also by usual process within a week from today. List after 4 weeks.
Obliged.
Timing item 9.
Well,
Counsel is absent.
but on the last occasion, my friend was saying that he will to be taken up 2 months.
2.
I'm not, on that day he was saying it.
Okay, come at 2 then.
Well,
Nine. Hmm. So we will resume at 2 then. Now we have no matters. Why?
My lord, in this case, my lord, because we have should have to argue, my lord, but due to some physical problem, he had to attend the physiotherapy session, my lord. He left the court premises.
Okay. On the request made by Mr.
M. Hassan,
M.
A. M. Hassan.
A.M. Hassan, learned counsel for the petitioner,
Respondent.
the appellant.
Lordship, they are for the appellant, they are for the respondent, Lordship. They are for the respondent, Lordship.
Acha, learned counsel for the respondent. Recess shall list the matter after
After vacation, my lord,
vacation.
lordship, date may fix, my lord. Any date, my lord.
On 19 November.
My lord.
Obliged,
Obliged,
not
Obliged, Lord.
objected by the learned counsel for the appellant.
Obliged, Lordship.
Yes, my lord.
Yes.
Item number 10, timing matter for personal appearance.
Recently on the way to from Zhuai to Guwahati and legal manager.
Sorry, we are vacating the order.
Tomorrow 10:30.
No.
No, legal manager has just arrived, my lord.
No.
You want to submit something, my lord?
No.
No, our mortgage creation is almost completed. It will.
Since when it is going on?
Funds will be into our account before the Puja vacation, Your Honor. So we want little more time.
No,
For
you
last
tell
time-
me how many adjournments you have taken on this ground?
Yes, Your Honor, but due to the mortgage creation, it is
Mr. Bhuya, for how many days it is going on?
2 years.
2 years.
Same thing.
and Your Honor,
Same thing, same repeatedly same submission before this honorable court.
So enough is enough.
Enough is enough, Lord.
and Your Honor, this
Enough
matter
is
is
enough.
listed with the investor. The investor will
Mm.
pay the entire amount to the DP holder, Your Honor. Just only 15 days time we require, Your Honor.
No. Heard, Mr. Your good name?
JC Google. No, actually,
Learned counsel for the appellant. And Mr. R.K. Bhuya, learned counsel for the respondent. Though by order dated 22/8/2024, the appellants were granted time for payment of the dues to the judgment debtor. Yet, again, the learned counsel for the appellant pressed for granting another 15 days time. Mr. R.K. Bhuya, learned counsel for the respondents, submits that this affairs is going on for last 2 years. And this or on this or that pretext, they have been taking time. And therefore, Mr. Bhuya has opposed granting further time to the appellants. Further, having heard the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, especially the orders passed in this appeal since the date of its admission. When it was admitted, Mr. Bhuya?
Lordship.
6/9/2022.
6/9.
2022, Lordship.
Mm. 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 Dated 6/9/2022. And in view of above, I find no just ground to grant further debt to the appellant. And accordingly, the pair stands dismissed. The interim order passed on 25/7/2022 is hereby vacated. List after puja vacation.
May I?
After vacation,
Lordship,
for final hearing.
In the meantime, my lord, if my lord, company paid the entire amount, my lord, because see, that.
No, you may mention the matter then.
Well, yes. That may
Otherwise,
be,
we'll
my
not
lord,
pass any
in the
order.
order, that may be, my lord, incorporated. If the payment is made, we may
No,
be allowed to mention, my lord.
no. No such permission is required.
If payment is made, my lord.
You can mention the matter.
mention. Hello.
Timing matter 9.
Counsel for the appellant is absent.
He was. He made. He has come. I think my friend is on last occasion, he has completed his argument.
Completed.
My friend has completed, so I can continue.
Okay.
Now to give response, whatever my learned friend will submit before this honorable court.
Okay. My lord, basic facts of the case are, my lord, that appellants, the predecessor in interest of the appellant, my lord, filed a suit for rejectment of the defendant, Anup Thakuria. In respect of the, my lord, the premises which was occupied by me, since 1991. Now, I was not aware of the, my lord, this suit filed by the predecessor in interest of the appellant's, my lord. And I came to know about this process, my lord, when the appellants tried to evict me on the basis of the decree passed by the trial court. And if, my lord, we go through the decree, my lord, then, my lord, it appears that the decree, it is there, my lord, in the page 22, my lord. Page 22 of the memo of appeal, my lord. And from the very heading itself, my lord, it appears that it is a judgment on admission, my lord. So, my lord, the plaintiff never came to the witness box, my lord. No evidence was adduced from the side of the appellants, my lord, in the suit. And the suit was decreed on admission, my lord, which alleged to have been made in the written statement by the, my lord, the defendant, sole defendant, Anup Thakuria, my lord. May take yours to the written statement also, my lord. That is a start from page 19.
He has basically, my lord, the defendant has basically admitted the claim of the plaintiff, my lord, that he could not make the payment of rent after making the payment of 12,000 for 2 months, for which the landlord the not issued any receipt, my lord.
Written statement is that page number?
Page 19, my lord. Page 19 of memo of appeal.
Yes.
My lord,
only
para,
two pages.
yes, my lord, only 2 pages. My lord, in para 2, it is stated that the defendant begs to state that with regard to the para 1, 2, and 3 of the plaint, that he admits the contention. Now, my lord, para 3, with regard to the para 4 of the plaint, the defendant begs to state that the defendant had paid rupees 12,000 in case to the plaintiff, for which the plaintiff did not receive any receipt. Now, my lord, the para 4 of plaint, may I just read, my lord? Page 15, my lord. That since beginning of the
Para 4 of?
plaint, para 15, page 15.
Yes.
That since beginning the defendant was irregular in payment of rent, the plaintiff did not condone such faults on the part of the defendant. Time and again, the plaintiff and her daughter-in-law, Srimati Babli Chatterjee, who was looking after all affairs of the plaintiff, cautioned the defendant to abide by the terms as laid down in the agreement, more particularly the mode of payment, but all these steps fell on deaf ears. Rather, since January 2009, the defendant not only stopped paying rent, but closed down his office house in the suit premises. The defendant has also stopped visiting the suit premises. After great deal of search, the son of the plaintiff could contact the defendant at his residence and by exerting pressure could realize rent for 2 months on 2/5/2009. Thus, the defendant is yet to pay rent for 7 months, commencing from February 2009 till date. So, my lord, this is the crux of matter, my lord, how the appellants, my lord, term the defendant should as
Mr.
defaulter.
Gore, now tell me whether there was any agreement between this Thakuria and this plaintiff.
I'm not aware, my lord, because there no evidence is there, my lord.
No evidence.
No evidence is there.
No, whether there is any mention in the this plaint regarding any any agreement.
Yes, it is there.
My friend said that it is there.
Page number?
I'm not aware.
Also, kindly see the plaint.
It's
The plaint starts from page number 14. The first paragraph, the plaintiff is the owner in possession of a RCC building standing in her own land measuring 1.115 such and such. She let out 1200 square feet at the eastern side of the ground floor of the said RCC building. More particular discount scheduled to the plaintiff in favor of the, with effect from 1/5/2008 by executing a bilateral agreement on 16/5/2008. The agreement was there, Lordship, and that was never been disputed by the defendant in his written statement.
No, have you produced that agreement before the court?
Lordship, that was produced before the court. That was a part of the document in the main suit, Lordship. And the
is
learned
it,
trial court also came to a
is
finding.
that document part of this memo of appeal?
Lordship.
Is that agreement part of
That
this,
I have
memo of
yes,
appeal?
because the issue is the person who occupied subsequently the premises, he filed an application under Order 20 and Rule 97 because the previous suit is over. After the obtaining the decree, when the another application was filed under Order 21 Rule 97, that particular application was rejected by the learned lower court, that means the executing court. And when he preferred an appeal, then appeal the reverse the previous finding with regard to the dismissal of the application. Now the second appeal, because that part with regard to the data and finality, because the person who is the respondent here, he was not a party to the original proceeding because he was not a tenant. And that is the reason why I have not annexed, because these are not relevant documents so far as to adjudicate the issue under Order 20 and Rule 97. Because Order 20 and Rule 97 is no way applicable with regard to the tenant. Because if the tenant is to claim his tenancy right, he has to file a separate suit under the Assam provision of the Assam Urban and Rent Control Act. He did not file any application under the Assam Urban and Rent Control Act because the declaratory suit. He filed a declaratory suit. As per the provision, he cannot file a declaratory suit. Although I have not challenged by preferring any appeal.
with regard to the finding of the trial court or the executing court. Now, what has happened when deciding that particular issue with regard to whether he was a tenant, there was not a single document, Lordship. The Lordship kindly peruse the evidence. Even in the cross-examination also, the present respondent who claims himself to be a tenant with regard to the suit property, he did not execute a single document establishing the fact that during the relevant period of time, 2008-2009, he was a tenant. Because this is our case, originally he was a tenant. Thereafter, when he handed over the position, the subsequent person who was a tenant, against whom the original suit was filed, he was inducted as a tenant to the suit premises. When there was a default, he admitted the default in his written statement, and accordingly the admission decree was there. Now, after the decree was put for execution, at that point of time, he came and he said, no, I'm in possession of the property, Lordship. And that is the issue. Now, if you are claiming yourself to be a tenant, you have to establish with a certain document that during the time when the suit was filed, at that point of time, you are a tenant. So far as the original landlord was concerned, there is no document, Lordship, because Uma Chatterjee was the previous owner of the property. After his demise, the Roger Chatterjee came into existence. So he should have exhibited certain document establishing the fact that he was having a tenancy agreement with Uma Chatterjee. What had prevented him to adduce or exhibit any document showing that he was having some agreement with Uma Chatterjee? That not a single document with the original owner, Lordship. And that is the reason why, Lordship, the executing court dismissed his proposition with regard to the fact that he was a tenant during the relevant period of time, Lordship. The learned lower appellate court appreciated the evidence or the exhibited documents, Lordship. Because it is not for the object, the respondent or the original tenant, the landlord, to establish the fact that he was a tenant. It is for the person who claims himself to be a tenant. As per the provision of section 101 of the Evidence Act, Lordship, this is a substantial question of law, that he has to prove his contents. Because if he wants the court to pass any certain judgment with regard to a certain fact, then he has to adduce evidence establishing the fact that he was a tenant during the relevant period of time.
Okay, yes, go on. Malad, so far my application is concerned, I'm just taking my log to page 34, Malad. Para 1, Malad.
Page 34.
Page 34. Married, Malad. That the objector of the decree is a tenant of the predecessor of the decree holder, late Uma Chatterjee, with whom an agreement was entered into in respect of scheduled premises, and has been a tenant since the year 1991 and has been continuously enjoying the tenancy till date. Para 2, Malad. On 24/2011, the bailiff of this court visited the premises of the objector and informed his employee that as per the order of this honorable court, the premises was to be vacated and given delivery to the decree holders. Immediately, the objector's employee informed him that few persons from the court had visited the premises and asked for Anup Thakuria, and further asked the employee to vacate and deliver possession. The objector immediately asked the employee to hand over the phone to the bailiff Nazir and spoke to him, and that the objector is a tenant in respect of the premises described in the writ, and not Anup Thakuria, who was a stranger, and as such no action may be taken. Now, I am just taking Lordship to page 40 of the objection, which the appellants have filed against this petition. Page 40. When I filed this petition, they filed written objection. And para 5 of their written objection, is at page 40. May read, that the statements made in para 1 of the application claiming that the objector is a tenant of the predecessor of the decree holder and that he has been a tenant since the year 1991 with respect to the scheduled premises are not correct, and the same are hereby denied. Fact thereafter, facts remain that he is a tenant with respect to 1,200 square feet at the second floor of the same building. However, in the year 1991, he had taken the suit premises on rent from the predecessor of the decree holders by executing a deed of tenancy on 1/4/1991, and the same was in force for a period of 3 years up to 31/3/1994. However, the tenancy continued till March 2005, and as the room was kept unused without any purpose, he handed over vacant possession of the suit premises in favor of the predecessor interest of the decree holders in the month of March 2005. Thereafter, Sri Anup Thakuria took the suit premises on rent on 16/5/2008
by executing written deed of rent agreement and came into possession of the suit premises thereby. As he failed to pay the rent thereafter and became a defaulter, the predecessor in interest of the decree holders instituted the title suit number 472 of 2009 for his eviction on the ground of default and bona fide requirement, and in as much as that in the meantime her son, namely decree holder, resigned from his earlier job and decided to start a shop of his own. The statements made in the by the objector, therefore, that he has been a tenant till date with respect to the suit premises is a diversity of truth, and this is why the objector is not in a position to show any scrap of paper for payment of rent for the subsequent period to 31/3/2005. So, my lord, this fact is admitted that my tenancy with respect to the suit premises started from 1/4/1991 and it continued till my lord 31st March 2005. So, my lord, this fact has been admitted by the decree holder appellants, my lord. And my lord, the provisions of section 58 of my lord evidence act says that admitted facts need not be proved. Section 58 of evidence act. So, my lord, since my tenancy from 1/4/1991 to 31/3/2005 is admitted in their written objection, there is no necessity of my lord producing any rent agreement from 1991 or any other proof that I was a tenant, because they have admitted, my lord. Now, my lord, I am just taking a lot to my lord to the report of the my lord after the decree, my lord, they file execution proceeding, my lord, which was registered as my lord title execution number 8 of 2011. In the when my lord the bailiff Nazir went to my lord the suit premises, he submitted a report, my lord. That report must be, my lord, the report lordship in the case report LCR, my lord. May I just read, my lords? My lord, this writ was issued on 18/4/2011, my lord, directing the Nazir to report on or before 27. Perhaps, my lord, the next date was 27/4/2011, my lord. It is mentioned in the side of, and my lord, the report of the Nazir is there, my lord, on the back side of the writ, my lord. May I just read, my lord? My friend has given the translated copy also, my lord. Here, my lord, is the signature of Rajat Chatterjee on 20th of April 2011. And the Zarikarak signature Subal Deka.
These are all question of fact.
No.
Second appeal is on question of law, lordship. He is just citing
No,
on
but-
signature, then bailiff. Like,
I
how
have not
these are all relevant, lord?
I have not objected when you are submitting. My lord, this report says, my lord, it is to be prayed that on 20th April 2011, the Seristadar and Zarikarak visited the place of scheduled premises. It is seen that there is a lock in the door of the scheduled house. One Pramod Lal Karan raised objection lived in the house. In the scheduled house, Sri Anup Thakuria not resided where Sri Tarasan Nata is residing. It is necessary to take help of the police for breaking the lock and take possession. So, my lord, it is not me, my lord. It is the Zarikar who visited the, my lord, to execute a decree. He has reported that this suitcase is in my possession, my lord. In the year 2011. Now, my lord, the appellant's case is that, my lord, I vacated the suitcase in the 31st March 2005. Then, my lord, they rented out on 16/5/2008 to Anup Thakuria. If, my lord, if their contention is, my lord, to be believed, then when
That report is part of the record.
my lord, it is part of the record.
In the LCR it is there.
LCR, my lord.
You marked it in the LCR
My-
also.
So, my lord, if that is the position, my lord, how I can in the when the decree was to sort to be, why, how the possession can it can be in my possession, my lord? So their suit is, my lord, totally false, my lord, and false and fabricated. They, in fact, my lord, they played a fraud in connivance with the, my lord, Anup Thakuria and obtained a fraudulent decree, my lord.
Mr. Gore,
Already
you
the-
first complete your argument.
My lord,
Thereafter,
that
you
is,
can
my
mark
lord,
it.
a record of execution is not, I think it is not here. The record of title suit is there, my lord,
Okay.
and the other miscellaneous cases record is there. My lord. So, my lord, so, my lord, from these facts, my lord, it is clear that I continued in possession since, my lord, 1/4/1991, and perhaps till date I am in possession. Secondly, my lord, I am just taking your lordship to, my lord, the evidence. I filed my evidence, my lord, in support of my objection, my lord.
Page number?
My lord, I'm sorry, my lord, that page number, I obtained copy from my friend, my lord. It may be here. It may be here. Yeah, I'll, my lord, I put a flag, my lord. I may take your lordship to, my lord, the
My evidence is also, my lord, not there.
Pardon?
Evidence of the, my lord, the respondent is also not there. Evidence, I file evidence on affidavit, I was cross-examining, I exhibited some document also, my lord,
কবে হয়? File আছে?
not, there are,
File আছে?
there are two files, my lord, in file also.
So these are the files we have
Yes,
received
yes,
from
my
the
lord. Yes, my
trial
lord,
court.
but my lord,
Execution case
not
call
complete.
করা আছে। Now where it is available in the execution proceeding?
No, my lord, there was, when I filed the application, my lord, a separate miss case was registered. my lord.
Appeal record করতেছি, appeal record trademark করা আছে।
So, yes, my lord, it is there. But it is not original. Miss case. It is along with the appeal, my lord, when I filed my lord, the trial court said, passed order against me, my lord, then I filed appeal, my lord. In appeal, a copy was given and that is given.
It is available.
But the original is not. So it may just have a look at.
So that miss case has not been received.
No, this case is there.
It is
but-
there, lordship. It
This
is
case
already
record is
trademark.
there, but evidence is not there. It is there. This case, 4120 for 2011.
Trademark.
It is there.
It is miss case. Oh. Okay,
Tier number,
something like that.
tier number 104. It is miscase. Anyway, my lord, this effect is not disputed because my friend is also having the copy and I also obtained from him.
Okay.
May, my lord, this affidavit, examination chief on affidavit of objector of the decree, my lord. My lord, may I read, my lord? Para 1, my lord, that I am a tenant under the decree holder and also the objector of the decree. I have been a tenant of the predecessor of the decree holder, late Umar Chatterjee, with whom an agreement was entered into in respect of the civil premises and has been a tenant since 1st April 1991 and has been continuously enjoying the tenancy till date. There are two, my lord. I say that during the occupation of tenancy premises on 1/4/2006, a raid was conducted in the premises by Inspector of Food and Civil Supplies, Bureau of Investigation Economic Offences, BIEO, whereby few LPG cylinders were seized by the said officials. Later on, statement of witnesses were recorded. The officials recorded the statement of the landlady, that is predecessor in interest of the decree holder, beside other witnesses. In her statement, Uma Chatterjee has categorically stated that I am a tenant under her, and there is as such a tenancy between me and the decree holders, which continued even till date. Exhibit 1 is the FIR along with statement of witnesses. So, my lord, their contention that I vacated the room, my lord, on my own on 31st March 2005. This fact, my lord, belies from this statement, my lord, that on 1/4/2006, after, my lord, about 1 year, a raid was conducted in my premises, my lord, this is premises, my lord, by the officers of BIEO, my lord. And, my lord, if this fact, and I annex the FIR also, my lord, if this fact is, my lord, during the cross-examination, no question was put, my lord. No question was put on this aspect, my lord. So this fact remain, my lord, uncontroverted. Now, my lord, other fact, my lord, para 3, my lord, that I say that the decree holders in collusion with Anup Thakuria procured a decree by playing fraud upon the court. I say that decree holders have sworn false affidavit stating that I have handed over the possession of the supervisors to the predecessor in interest of the decree holders in the month of March. It is absolutely a false statement on oath, as the said fact is belied by the documents in which the predecessor in interest of the decree holder herself stated before the authorities that the objector was carrying on business on the ground floor of the building belonging to her.
para 4, my lord. I say that in order to save his skin from facing proceeding for playing fraud upon the court, the decree holder entered into a agreement on 10/6/2011 with me, wherein the tenancy has been shown to exist continuously since 1st April 1991. It is therefore established that I am in occupation of the premises since the inception of the tenancy continued from 1st April 1991 and still continuing till date. Exhibit 2 is the house rent agreement dated 10/6/2011. Now, my lord, my friend on last occasion contended that I did not produce any agreement regarding my tenancy, my lord, from 1/4/1991. And this agreement executed on 10/6/2011 is a subsequent agreement, my lord. So, the respondent, my lord, clarified how this subsequent agreement has been, my lord, executed. Because my ground before the trial court was, my lord, that the decree has been obtained by playing fraud in convenience with Anup Thakuria, my lord. And, my lord, and I also prayed for taking action against the, my lord, the persons who have shown false affidavit before the court, my lord. So, my lord, just to avoid that, my lord, consequences, the this decree holder, my lord, executed this agreement with me, my lord. And I am just taking lordship to the agreement itself, my lord, that is also there, my lord. May it just, my lord, one paragraph from that agreement, my lord. In the, my lord, this recitals, it is stated that where may read, my lord, whereas the landlord is the absolute owner of RCC building covered by ordinance number such and such, Guwahati Municipal Corporation tending on for such and such, more fully described in Schedule A herein below. And whereas the landlord has approached the tenant with an offer to let out a house measuring about approximately 1,200 square feet in the area of constructed building on the ground floor, and the second party has agreed upon to take the said house on monthly rental system at the rate of 6,600 per month. Now, my lord, terms and conditions, my lord. Number 1, that the tenant second party has been continuing their tenancy at the above mentioned tenant premises since 1st April 1991, my lord. So, my lord, although this, my lord, agreement exhibit 2, my lord, is executed on, my lord, 10/6/2011, but, my lord, it contains the statement that the agreement, it is the tenancy, my lord, created from 1/4/1991, and that tenancy still continues, my lord. So, my lord, the entire, my lord, the projected case of the appellant that I vacated the premises on 31st March 2005. Thereafter, they rented it out to Anup Thakuria on 16/5/2008. Anup Thakuria failed to pay the rent from February 2009, and they filed the suit for ejectment in the month of, my lord, perhaps September 2009. All these, my lord, projected facts are, my lord, patently false, my lord. This agreement has been executed by, my lord, the predecessor interest of the present appellant, my lord, Rajat Chatterjee. Suit was filed by my lord, Uma Chatterjee. She had one son and one daughter, my lord. After her demise, my lord, Rajat Chatterjee, her son, and Mosmi Bhattacharjee, her daughter, my lord, they were substituted in the suit, my lord. And when I filed the, my lord, then these two persons were, my lord, decree holders. So, in between, my lord, this Rajat Chatterjee has entered into this agreement, my lord. And maybe, my lord, at that point of time, the rent may have been of a smaller amount, but he has also enhanced the rent, my lord. And this, thereafter, my lord, they also, in the 2013 also, my lord, he issued 2 receipts, my lord. Now, my lord, their allegation is that, my lord, this Rajat Chatterjee was, my lord, not mentally fit. And so I obtained his signature on blank paper, whatever they say, my lord. At that time, he was not mentally fit to execute any document, my lord. Now, my lord, if their allegation is also, my lord, believed by their own statement, my lord, because this agreement was executed by Reserve Secretary in my favor on 10/6/2011, my lord. And on 2/6/2011, my lord, this same Reserve Secretary has executed a general power of attorney in favor of her, his wife, my lord, Public Secretary. So, my lord, if he was fit to execute a power of attorney on 2/6/2011, my lord, how he can be said to be unfit on 10/6/2011, my lord? So all these facts, my lord, the burden lies on them to prove. My lord, Section 106 of my lord, the evidence act says that a special fact, if a party alleges a special fact that such and special things were in existence, my lord. Like in this case, my lord, they say that from 31st March 2005 to this 10/6 to I was not in possession. I vacated the premises. These and they visited it out to Anup Thakuria. Well, these facts they have to prove, my lord. The burden lies on them to prove that in between Anup Thakuria was in possession of the premises, my lord, not me, my lord. And thereafter, my lord, and my lord, this lady, my lord, Babli Chatterjee, the plaintiff herself has admitted, my lord, that this Babli Chatterjee, her daughter-in-law was, my lord, looking after all the affairs of the property, my lord. If we go through, my lord, the my lord, record of title suit, it is apparent, my lord, many times she has filed the petition, although at that time Uma Chatterjee was alive, my lord. But she has filed many petitions, my lord. Thereafter, in the year 2011, she obtained power of attorney, my lord. And she is also, my lord, she was an educated lady working in a nationalized bank, my lord. That fact is also admitted in their power of attorney, my lord. Now, my lord, they say, apart from this agreement, my lord, this Reserve Secretary landlord has also issued 2 money receipt, my lord. Money receipt for 2 months, my lord. That money receipt also, my lord, exhibited as exhibit, my lord, 4. A type copy is there, my lord. Handwriting is also there, my lord. Here he has stated, my lord, that received from Mr. Taratan Nata rent for the following months, my lord. November 2013, 13,486, check number such and such, dated 6/11/2013. Number 2, my lord, December 2013, 13,487, check number such and such, dated 2/12/2013. Now, my lord, they say that this receipt was also, my lord, fraudulently obtained. And they my lord, they have submitted some documents, my lord, whereby the, my lord, the doctor stated that this Reserve Secretary was, my lord, a chronic alcoholic. So, my lord, if we assume that these receipts have been, my lord, he has issued in under the influence of, my lord, alcohol. If, my lord, for the moment we assume, my lord, even then, my lord, the fact remains, my lord, that his wife, Babli Chatterjee, who was the attorney holder, my lord, she was working in the bank, my lord. She knows everything. My lord, I have not made the payment in cash, my lord. I have made the payment of this rent, my lord, by check, my lord. And certainly, my lord, a drunkard cannot, my lord, go to bank and obtain the payment. If he is in the state of, my lord, drunkenness, so for cash payment, my lord, he can. But certainly, my lord, these checks have come to, must have come to the hands of, my lord, this Babli Chatterjee, attorney holder of this, my lord, Reserve Secretary. She was not, she is admittedly, my lord, a fit person. So, my lord, how they can deny, my lord, that I was not in possession of the premises. I just filed this objection to harass them, my lord. What I have to go get, my lord, from all these things, my lord. So, my lord, the learned appellate court, Lord Appellate Court, my lord, he has rightly passed the decree in my favor, my lord, holding that the defendants, the plaintiff, my lord, plaintiff has played fraud on the trial court, my lord, and in collision with this Anup Thakuria, they obtained the fraudulent decree, my lord. And the learned First Appellate Court has also, my lord, referred to a judgment of Honorable Supreme Court, my lord, on fraud, my lord. It was in the case of it is reported in 1994 one SCC, my lord, page 1. The judgment of my lord, lower appellate court start from page 55, my lord.
$55 of memo of appeal.
My lord. And the relevant portion is, my lord, page 59, my lord. Page 59, my lord.
Yes.
The learned first appellate court has framed, my lord, 2 points for determination of the appeal, my lord. Number 1, whether the objector a decree is a tenant under the respond number 1 in respect of the suit summarizes in which is the subject matter of title execution number 8 of 11. Number 2, my lord, whether decree passed by the London Municip in title suit number 470 of 09 is an executable decree. I heard the argument submitted forwarded by Learned Counsel of both the sides. Also peruse the impugned judgment and other materials available on record and arrive at the decision on the points. Now I'm taking the yes, my Learned Court below, my lord, consider both the points. Whether the point number 1, my lord, the materials available on record disclose that the appellant set at justice delivery system in motion by filing a petition claiming that the decree holder is in collusion with the judgment debtor, fraudulently obtained decree from the trial court as supervises in respect of which decree and eviction order has been obtained is in possession of the appellant in the capacity of tenant since 1991. In pursuance of the landlord tenancy relationship with the predecessor in interest of respond number 1. And subsequently, with the respond number 1, by tenancy agreement dated 2011, marked as Exhibit 1, is further alleged that Anup Thakuria's judgment debtor is a stranger to the suit provisos and belief on the strength of the decree went to evict the appellant from the suit provisos, who is the original tenant and occupy the suit provisos, and for which he was compelled to take the shelter of this court for seeking justice. The appellant, in order to substantiate his claim, also exhibited his rent agreement dated 10/6/2011 as Exhibit 1, wherein it appears that the facts regarding landlord tenancy tenant relationship in respect of the said suit provisos of appellant with respondent and predecessor of respondent since 1991 is shown to have been admitted. Further, if we peruse the Exhibit 1 meticulously, we will find that it is a notarized document. So a statutory presumption of its due execution in the light of section number 114 illustration E of Evidence Act would arise in favor of the appellant. However, it is contended by the respondent that the aforesaid rent agreement is a fraudulent document, as appellant has allegedly exerted mental pressure on the respondent while he was in the state of unsound mind and fraudulently obtained his signature over some blank paper and have converted the same into rent agreement. Now, if that be a position, then in my considered opinion, the burden of proof as to the forces alleged creation of fraudulent document and as regard unsound mind of the defendant at the relevant time period lies upon the defendant in view of the provision of law laid down under section 101, 102 of the Evidence Act. When the defendant has admittedly put his signature over the disputed document. But if we peruse the evidence available on record, we will find that there is no iota of evidence from the respondent decree holder side to establish the aforesaid fact, nor there is anything to suggest as to how the appellant has come to the possession of the suit premises at the relevant point of time when bailiff of the court visited the suit premises for eviction of one Anup Thakuria. If he is not a tenant, further, there is also nothing to suggest as to how he remembered the fact that the appellant has exerted mental pressure upon him when he was allegedly mentally ill. We know that a mentally ill person, a person of unsound mind, is not expected to have knowledge of anything, and he is not expected to distinguish between the what is mental exertion and what is not. Now, if the respondent claims that appellant has exerted mental exertion and fraudulently obtained signature in blank paper, then I am of the considered opinion that it is highly improbable that respondent was not in a proper state of mind while he put his signature over the disputed document. Further, his silence as regards alleged creation of the fraudulent deed for such a long period of time without informing about the aforesaid fact to his near and dear ones or to police creates serious doubt over his claim. So, under aforesaid facts and circumstances, I am of the considered opinion that the facts alleged by the defendant is erroneous and hence his case stands disproved. In consequence, I am constrained to hold that notarized rent agreement coupled with the possession of the appellant over the suit premises established the fact that there was allegedly landlord-tenancy relationship between the appellant and predecessor of the respondent since 1991 and subsequently with the respondent number 1 by virtue of Exhibit 1. So, in view of the aforesaid discussion, I am of the considered opinion that order dated 9/6/2016 passed by the London Municip in this case number 412 of 11 is not sustainable as the decree was obtained without impleading appellant as a party and accordingly it is set aside. And consequently, the execution proceeding become infructuous as the decree is not executable. So, my lord, admittedly, the possession of the suit premises was in under me, my lord. And the fact, my lord, that I was a tenant since 1/4/1991, this fact also, my lord, remain admitted by the appellant, my lord. So, my lord, the burden lies on the appellant, my lord. How in between, my lord, this Anup Thakuria came into picture, my lord. And when he came into picture, and my lord, from the very, my lord, fact, from the very written statement of the Anup Thakuria, it is, my lord, clearly established, my lord, that fraud has been committed. Because otherwise, my lord, how a tenant, assuming for a moment, my lord, that suit is filed against a tenant, my lord, for eviction, and he is carrying on his business in the suit, it is a commercial premises, my lord. How, my lord, a person can admit, my lord, knowing fully well that tomorrow he will be evicted from the suit, he will be, his earning will be stopped, my lord. How such a person, my lord, can admit that, yes, I am a defaulter, I could not make the payment of rent? It is highly improbable, my lord. So the very written statement filed by Anup Thakuria or vote filed by the appellants from Anup Thakuria, my lord. Anup Thakuria, my lord, may be in collusion with them, my lord. They pollutely file a suit that says we will obtain a decree in the name of Anup Thakuria and we will get evicted to this respondent, my lord. So these facts are, my lord, clearly established. And, my lord, the appellants have, my lord, thoroughly cross-examined. I filed my evidence on affidavit, my lord. They have thoroughly cross-examined me, my lord. But, my lord, they did not, my statement, my lord, that a raid was conducted on my premises on 1/4/2006, my lord. After their alleged, my lord, ending over the termination of the tenancy. These facts, my lord, remain uncontroverted, my lord. And by statement also, my lord, that the suit is still in my possession. And this agreement was subsequent agreement on 10/6/2011 was executed by Rajat Chatterjee, the predecessor in interest of the my lord appellant. All these facts, my lord, remain uncontroverted, my lord. And the suit is still in my possession, my lord. And my lord, apart from it, my lord, admittedly, my lord, I am also a tenant in respect of my lord a flat, residential flat on the second floor of the same building. My lord, how it can be, my lord, possible that I fail to make the payment of rent for the first floor or for the ground floor, but I am making regular payment of the, my lord, the second floor? Highly improbable, my lord.
Okay.
My lord, I am submitting some judgments of honorable. My lord, the one judgment, my lord, could not I forget, my lord. It was reported in 1994 one SCC regarding fraud, my lord. Fraud as in, my lord, categorically defined in that judgment, my lord. Other judgments, my lord.
So you give the citation?
My lord, 1994 one SCC.
Page number?
Page number also one. One page number one.
One.
Page number also. Then, my lord, two, 2019 15 SCC, my lord.
You submit those judgments?
I am giving this. 2015, my lord, it is in the case of these are all, my lord, that it's a burden of proof. And, my lord, no evidence, my lord, assuming, my lord, that the statement made in the plain are correct, but, my lord, they must be proved in by evidence, my lord. There is no evidence at all, my lord. Even the statements made in the plain that it was rented to the
That's all right, but it is admitted in the written statement.
no, it is admitted, but my lord, when I disputed, my lord, that he was never in possession, then, my lord, they must have filed, they must have some evidence, my lord, in this miscellaneous in my petition, my lord. So evidence, my lord.
Let me clarify one aspect of the matter one the learned friend has said.
Hmm.
With regard to one proof, he is relying on one proof, that is, it is exhibit one, is the FIR, because there is no other evidence on record which will substantiate the fact that he was a tenant during the relevant period of time. Worship knows it very well, that if I have to establish certain facts, I have to prove those facts. Because if he is saying that he is a tenant during the relevant period of time, he must produce certain landlord-tenant agreement. He could not produce any landlord-tenant agreement. Now, with regard to the exhibit one FIR, the statement was that in paragraph number 2 of the evidence, the examination in chief, that I, during the occupation of the tenanted premises on such and such date, on 1/4/2006, a raid was conducted in the suit premises by the Inspector of Food and Civil Supplies, Bureau of Investigation, whereby few LPG cylinders were seized by the said officials. Later on, statement of witnesses were recorded. The official recorded the statement of the landlady, that is predecessor interest of the decree holders, beside other witnesses. In her statement, Uma Chatterjee categorically stated that I am a tenant under her and there is as such tenancy between me and the degree holder. So the learned friend is trying to project.
No. Yes.
So my learned friend is trying to project that because of the statement of the landlady, his burden has been shifted to the other side. Now what has happened, Lordship, the evidence is complete after taking into account the cross-examination part also. What I have stated in the evidence on affidavit is not the evidence, because cross-examination is also to be taken into account to determine the actual facts, so far as the contention of the objector is concerned. Now in the cross-examination, Lordship, he has admitted two things, which is very relevant, Lordship. In the cross-examination, he has stated, I'm just reading those two relevant paragraphs, Lordship. I have my rented residence in the premises of late Uma Chatterjee on the second floor. I have also taken on rent the ground floor consisting of 4 rooms. 4 rooms. That means he has 2 rented premises in the residence of Uma Chatterjee. Now, what he has stated with regard to the cylinder, he has mentioned about the fact in the third page, Lordship, the last paragraph, I have never kept any LPG cylinder in the suit premises, but I used to keep it in the baranda. So that means what he is stating in the evidence, he has completely denied that aspect of the matter in the cross-examination, that he did not keep any cylinder in the suit premises. Now, when he was having two room tenanted premises in the residence of late Uma Chatterjee Lordship, and at the same time he is admitting the fact he did not keep any cylinder in the premises of in the suit premises. In that view of the matter, Lordship, establishing the fact that the objector was a tenant during the relevant period of time based on exhibit 1 is not maintainable, Lordship, and this is not absolutely not sustainable in view of the cross-examination that was done during the relevant period of time, Lordship. Because in his cross-examination, he has denied the fact that he kept any LPG cylinder suit premises, and at the same time, he has admitted the fact that he was a tenant with regard to two premises, Lordship. One is the suit premises, and another is another premises in the second floor, Lordship. So in that view of the matter, Lordship, there is no evidence, and 101, this is a substantial question of law, Lordship, with regard to section 101 of the Evidence Act, is the objector failed to establish his burden so far as the tenancy is concerned, Lordship. For the learned lower court, Lordship, the trial court, the executing court, was the judgment dismissing the application by properly appreciating the evidence and the materials available in the law court, Lordship.
Okay, we'll see. Pardon, Mr. P.S. Sudhuri, learned counsel for the.
I will submit to judgment, Lordship. Give a photocopy of the judgment.
Pardon?
To judgment, Lordship, Supreme Court judgment, Lordship.
Pardon, Sir, the court master. Mr. Jessigur, learned. Argument concluded, judgment is there.
Timing, Adam? 14 to 16?
No,
Mhm. 25. Not now. Item 25.
Mm, 2 p.m.
Yeah, please, Your Lordship. So before starting the argument, I want to place an application which is a subsequent development, my lord. Subsequent to the filing of this appeal, so we want to bring it on record, my lord. Because an order under 6 Rule 17 for amendment of the plaintiff's file, and why we want to bring it, my lord? Only the amended prayer that is made at page number 8 may be seen, my lord. A, B, C, D, B, C, B, D, E, F, G, H, I. To add stroke incorporate in the prayer portion as prayer number 4B, directing the main defendants to remove the obstruction raised by them over the civil D-land, to open up and to use as ingress and egress to the residence of the plaintiff for the civil D-land, as well as to remove all other constructions raised by them over the suit land. Furthermore, my lord, why I am pressing this, there is an order passed by this honorable court dated 24/5/2024 in the IA 1421/24. I am referring to the order dated, my lord, 24/5/2024.
Yes.
Whereby stay order was granted, and lordship may be pleased to see the para 4 of the order on the page number 3. May I read out, my lord? The said stay order has been passed, taking into account that from perusal of the order dated 29/4/24, it seems that the learned trial court, while passing those directions, failed to take into account that the mandatory injunction so issued would amount to permitting the plaintiff to enter into the civil D-land, which is the final relief, or for that matters amount to partly declaring the suit at this initial stage, that too, when the plaintiff, even prior to filing of the suit, claims to be dispossessed from the civil D-land. The same is a prima facie. So that's why, my lord, on Monday, we will file. By way of additional affidavit, we will bring it on record, this amended petition.
How this will help you?
My lord, because the matter is, in view of this order, my lord, what actually happened, in my submission, I want to say that this amendment application was filed after the discourse that took place in the month of May. Because while we are pressing for the stay order, and as a whole, the matter of appeal before Honorable Justice Devasis Barua, so there he comes to know about the defects in his case. So this prima facie view that is taken by the court, now in terms of this prima facie view, he has also prayed for amendment of which in the prayer portion even, my lord. Because there are total 4 schedule of land are mentioned. Schedule A, Schedule B, Schedule C, and Schedule D. And as per the statements made in the plain, Schedule B and the Schedule C consists Schedule A. And in regard to Schedule B land, there is a registered sale deed. He has mutation over that. The plaintiff has mutation over the Schedule B land also. And in regard to the Schedule C land, my lord, there is an agreement for sale. And later on, the version of the plaintiff is that in connection with the Schedule C land, the prospective sellers have also given one NOC and one general power of attorney, that too on an stamp paper of ₹10, and possession was also handed over to him. And in this way, he is now occupying and possessing the Schedule B and the Schedule C, which comprise the Schedule A land. So Schedule A consists of, my lord, 1 bigha, I think. 1 bigha land. So as certain developments are there, my lord, because he is claiming that his right of path is ingress egress is blocked by us, and that very order of mandatory injunction is put under sellings. So we want to bring it on record because this is the final ruling. This application for amendment may be allowed, although it is not in the present plane, this prayer. So if it is allowed, so it will be in the final. It will be a decree that will be decided after the end of the trial. That's why we want to bring it on record, my lord.
Lordship, whatever he is saying that prayer portion also going to be amended, it's a wrong, Lordship, a wrong statement. As on today, they have not objected despite of 3 months is over to that amendment petition application. They have not filed any objection to that. Even on last to last occasion, they did not attend the court also without taking any step, without putting any hazira. I have records. So he is going differently. Lordship, main is whether at that point of time when honorable court, trial court has passed the temporary mandatory injunction order, that time these facts were not there. Amendment petition, they may object. There will be hearing or whatever. 3 months over, they have not objected yet. Last sons has been given to them on last occasion. So that is separate issue, Lordship. Lordship, while passing the temporary mandatory injunction, it was purely temporary because they occupied my undisputed land, part of undisputed land, that is Schedule D, and they clouded my other part of my land because they occupied my entrance. My ingress and egress is closed. I could not enter to my entire premises. Lordship, that my undisputed land, I have buildings, I have house, I have home, Lordship. It is home. It is not only house, Lordship, it is home. I'm away from my home. My family is away from my home for last 1 year, Lordship. And these facts well understood after hearing, after giving objections, everything, after Amin Commission's report acceptance, it is acceptance directly or indirectly, Lordship. They will say it was not accepted. They have written here also, it was not accepted. Lordship, it was considered. Lordship, they have not objected Amin Commission, so moto Amin Commissioner's report, Lordship. And after going through photograph, it is stated in the order, Lordship, the trial court has finally passed temporary mandatory injunction, Lordship. It is temporary, and my ingress and egress to my home, Lordship, not to a factory or not to a other premises. It is my home, own home. It is inhuman. It is inhuman, Lordship. That time, my only son was 17 years old, and my son was supposed to appear 10+2 examination. Before examination, Lordship, they have occupied my land, and they have occupied with police. I had to file writ petition against the police, Lordship, against the police. I have dared to do that. Even the commissioner, even the deputy commissioner, OC, IC in person, Lordship. I had to go up to that extent, Lordship, as a simple citizen. And now he is dragging, somehow petitioner, this appellant is dragging the case for long, so that I become compelled to sign wherever they want and take my entire land. That's it, Lordship. It is up to the Lordship whether hearing may continue or whatever. That part, amendment petition, is the matter of trial court, Lordship. Let that be heard separately at trial court. When that amendment petition will be accepted finally by the trial court, then it will be considered by this honorable court as well, Lordship. If till then, another 3-4 months or 6 months, it will take.
So,
Lordship.
Mr. Bora, how this application is relevant in this proceeding?
Because, my lord,
Hmm?
I'm showing it, my lord.
Whether amendment is necessary or not, that will be decided by the trial court after hearing both
Yes,
sides.
right, my lord.
Mm.
But the point is, my lord,
Mm.
now, if your lordship comes to page number 40
Mm.
of my memo of appeal,
Mm.
there the prayers of the plaintiffs are there. First, the prayers may be seen.
Mm.
Prayer, page number 40. 1. Declaring plaintiff's right, title, and interest over the civil D land.
Mm.
2. Declaring confirmation of possession over the remaining portion of civil D land, except the land described
Mr.
in
Bora, you see, we are not on that now.
Yes,
Appeal is filed against what?
against the order of mandatory injunction.
Then,
So, my lord, as because I am reading out,
mm.
as because there is a prima facie view.
Mm.
Why? Here, my lord, the prayer 3,
Mm.
that is recovery of khas possession.
Mm.
So, recovery of khas possession by evicting the defendant number 1 to 4, their men, agents, attorneys, or any person claiming under them from the civil deal and demolishing the structures standing thereon.
Mm.
So, by passing that order, mandatory injunction order, which we have put under silence in the present appeal, it amounts to passing of this thing. And that's why Honorable Court already took a prima facie view. And that's why matter is stayed. And now by praying so, because here, now other side is saying that there is no such prayer. But these are the prayers he prayed in the amended application,
Mm.
amendment application.
Mm.
That's why we bring it into record.
No, not necessary. I don't think it
Then,
is
my lord,
necessary here.
then my lord,
You argued a matter.
I am now on the matter then. My lord,
Mm.
here in the plaint,
Mm.
lordship, there are total 4 schedules I have mentioned: schedule A, schedule B, schedule C, and schedule D.
Mm.
And lordship will get the reference of schedule A.
Mm.
Schedule, first of all, B, at para 6 of the plaint, that is on page number 33.
Yes.
That accordingly, the aforesaid legal heirs of late Harmohan Das, namely Sri Dhruva Das, Sri Kunjadhar Das, Sri Binoy Das, and Srimati Binu Das, sold a portion of land measure in 4 katas, covered by Doc number 691 new, AP Quota 306 new, out of the Schedule A land, which is more specifically described in Schedule B here under. So this is the 4 katha land which he purchased from these persons. Although these persons are not a party to the suit, even as pro forma defendants. Thereafter, Lordship, kindly para 8 of the plaint of this page. That during the process of sale of Schedule B land, the plaintiff expressed his willingness to purchase the remaining 1 katha land out of the Schedule A land, and the vendors of the plaintiff also agreed to the proposal, and to that effect, and accordingly an agreement for sale in respect of remaining 1 katha, which is more specifically described in Schedule C hereunder, was executed on 26 to 2019, and accordingly possession was also handed over to the plaintiff. The said vendors also executed an NOC dated so and so and a general power of attorney dated so and so in respect of the entire Schedule A land comprising of Schedule B and Schedule C. So B plus C is equal to A. It means for the purpose of empowering the plaintiff to develop the said land and to construct a RCC building therein. So thereafter, my lord, how he got the Schedule B, how he got the Schedule C, and now lordship will get the reference of this Schedule D in para 21, that is page number 38. Para 21 of the plaint. Page number 38, para 21, my lord. The taking advantage of the absence of the plaintiff, the defendant number 1 and 4 encroach upon some portion of the Schedule D land and hurriedly constructed 2-3 bamboo fenced house in some portion of the northern side, southern side, and eastern side of the plaintiff's land, which is more specifically described in Schedule D hereunder. But how he got the Schedule D? He is also saying that the amendment application is not relevant. Then how he got the Schedule D? Nowhere it is explained. And the entire matter now centers around the Schedule D. Now what happened? After filing this injunction application, plaint, as well as on the injunction application, that is miscase 1000/2023, we have filed caveat, we entered into appearance, matter was moved, and while order dated 6/10/2023, and order of status quo was passed by the learned trial court, and also appointed Amin Commission. That lordship will find injunction 153 to 165. It starts from 153. My lord, I want
163.
It starts from 153, my lord. But I want to take your lordship to page number 163. 162, my lord. 162, the operative portion. At this stage, second para, my lord. At this stage, without discussing the merits of the dispute in hand, and also without having formal proof of documents and the pleadings, this court finds a bona fide dispute between the parties, which requires proper adjudication on having a full-fledged trial. The document submitted before this court by the rival parties makes it clear that there is a revenue appeal pending against the mutation of OP number 1, 2, and 3, and the same is still pending before the ADC Kamrup Metro. And in respect of land measuring 4 quarters purchased by the petitioner, there is no dispute since the petitioner is having his sale deed as well as mutation entry. Now, in respect of land measuring 1 quarter, which the OP number 1 and 4 are disputing that no valid title and right can be conferred since both the documents are not a sale deed or a deed of transfer. The question which raised before this court deserves proper adjudication, but prior to that, the court needs to ascertain whether there is any encroachment made by the OPs over the land of the petitioner, since both the parties are having documents in respect of Suddag and Potta, and without having any evidence, it is very difficult to ascertain that whether there was any encroachment upon the land of the petitioner by the OPs. Therefore, considering the nature of the dispute, this court thinks it deemed fit and proper to appoint an Amin commission to identify the land of the petitioner and the OPs and to submit report as to whether there is any encroachment made by the OPs over the land of the petitioner, and after arrival of the report, the court will decide the injunction application in accordance with law. In the result, the Circle Officer Dispute Revenue Circle is hereby appointed as Amin Commissioner to ascertain the following facts. 1. To ascertain the total land of the DAG number 691 of Potta number 306, whether land described in schedule A, B, C, and D is in possession of the petitioner, whether the land of the petitioner encroached by the OPs, the exact location and position of land of the petitioner, as well as the OP number 1, 2, and 3. Thereafter, my lord, page number 164. Second paragraph, my lord. Further, considering the nature of dispute, this court finds that there is an attempt of construction made over the suit property by both the parties, and if any permanent construction or structure is completed, till the Circle Officer Dispute Revenue Circle submits the report, then the very purpose of filing the suit may become infructuous, and there may be chance of multiplicity of proceedings. Under the aforesaid circumstances, this court finds that the subject matter of the suit requires to be protected from any aggressory act of the either parties, so that the subject matter remains intact till the court decides the injunction application in accordance with law. The settled proposition of law says that the subject matter of the suit only can be protected by way of granting an order of status quo, and justice should not be defeated if the parties are directed to maintain status quo till the Circle Officer Dispute Revenue Circle submits its report before the court and till the OPs file the written objection before the court. As such, an order of status quo is hereby passed by directing both the sides to maintain status quo over the suit property till the Circle Officer Dispute Revenue Circle submits its report before the court. So this is the operative part of this injunction order. Now, this order was passed on 6/10/2023. Thereafter, last year, the puja vacation begins. And just after opening the puja vacation, the plaintiff side has filed 3 applications. One is violation of injunction, that is order 39 rule 2A. That application, it starts from page number 166, my lord. That is registered as Mize case number 1054/2023. For violation of this order dated 6/10/2023. In Mize case number 1000/23 arising of title suit number 619/2023. Already in connection with this Mize case, plaintiff has filed his evidence and now matter is fixed for cross-examination. Thereafter, another application was filed for police assistance that lordship will find page number 194.
No, but that is not necessary here.
And thereafter, my lord, this mandatory injunction application.
Thereafter.
Yes, along with these applications, these 2 applications, because
So
on the
after
same
this,
set of allegations.
after the status quo, this mandatory injunction was granted.
Yes. It was granted in the month of April this year, my lord. The order that is put on the salience.
Let us go to the order.
My lord. The impugn order, it starts from page number 386, my lord.
Yes.
386. I'm reading out, my lord.
Mm.
Both sides are represented. Today's fixed order on the last, both sides were heard at length. By this order, this court proposes to dispose of the instant miss. The case arose out of a petition filed by the petitioner under Order 39 of the Specific Relief Act 1963, praying to pass an order of temporary mandatory injunction to remove the structures and open up the right of way for the petitioner's free movement through his vehicles for ingress and egress to his building standing over Civil B and a part of Civil A. The petition was filed under Order 39 of the Specific Relief Act 1963, supported by an affidavit and photostat copies of certain documents. The petitioner's case concerns a piece of land measuring 1 bigha, which late Seniram Das previously owned. After his death, his legal heirs Robin Chandra Das, Povin Chandra Das, and Joydev Chandra Das inherited the land as per inheritance laws. The land was sold to Sri Harmohan Das on 6/6/1963 through a registered sale deed number so-and-so dated so-and-so. Harmohan Das mutated his name on the strength of the sale deed, and after his death, the land was inherited by his legal heirs Sri Dhruva Chandra Das, Sri Kunjadhar Das, Sri Binoy Das, and Srimati Binu Das. These legal heirs sold 4 kothas of land covered by Dag number 691 new 493 old of KP Pota number 306 new 144 old, which is described in Schedule B to the petitioner through a registered deed of sale, deed number 7690 on 5/8/2019, after obtaining the necessary sale permission. While selling the Schedule B land, the petitioner expressed interest in purchasing the remaining kotha of land described in Schedule C from the vendors. The vendors agreed to the proposal, and an agreement for sale of the remaining 1 kotha was executed on 26/2/2019, and possession was handed over to the petitioner. The vendors also executed an NOC dated 27/10/2017 and a general power of attorney dated 12/9/2018 in favor of the petitioner, enabling them to develop the entire Schedule A land comprising Schedule B and Schedule C land and constructed an RCC building on it. The petitioner was granted permission to build 2 RCC structures on Schedule B and Schedule C lands. However, the OP number 1, 2, and 3 claimed ownership of the land covered by Dag number 691 new, 493 old, and KP Pata number 306, based on a purported gift deed executed in favor of their predecessor by one Moram Koiporto, who did not have any right to gift land in the Dag and Pata in question. The petitioner filed applications for cancellation of the mutation orders, and finally, a revenue appeal before the Deputy Commissioner was registered on 22/3/2022. On 18/8/2023, OP number 4 and a team of 20 people and laborers trespassed into the Schedule A land and broke the southern fencing. The OP number 4 is acting at the behest of the OP number 1, 2, and 3. The additional Deputy Commissioner Kamrup Metro passed a prohibitory order restraining the OP number 1, 2, and 3 from constructing anything till disposal of the appeal. However, on 26/8/2023, the said OP number 4 and OP number 1 and a group of around 30 goons vandalized the petitioner's property standing upon the Schedule A land. The petitioner lodged an FIR before Jalukbari Police Station and Director General of Police. On September 2023, OP number 1 and 4 brought officials to Schedule A land for demarcation. The circle officer left after objections were raised. Later, male and female accomplices of OP number 1 and 4 maltreated the petitioner's wife and snatched her mobile phone. An FIR was lost. OP number 1 and 4 encroached on Schedule D land and built bamboo fenced houses. The OPs broke CCTV cameras and were restrained by an ad interim injunction. On October 10, 2023, the OPs violated the injunction, raising a concrete wall and breaking the water borewell, blocking the petitioner's access. Hence, the petitioner filed a mandatory injunction to remove the structures and open up the right of way for the free movement of the petitioner through his vehicles. Per contra, the OPs have filed written objection contending that the instant injunction application filed by the petitioner is not maintainable both in law and facts, and further denied almost all the contents of the petition, save and except those statements or averments which are specifically admitted and matter of records, and put the petitioner to strict proof thereof. The OPs have further contended that the petitioner falsely submitted before the court and instituted the suit against the OP number, here it should be 3, omitted, since OP number 3 died on 6/7/23, that is prior to the institution of the suit, and prayer of the petitioner being the equitable relief cannot be granted to a litigant who is not approached the honorable court with clean hands. The OPs further stated that the petitioner had suppressed the material fact about the death of OP number 3 and hence prayed to dismiss the prayer of the petitioner with cost. Admittedly, the matter relates to the application filed by the petitioner under section 39 of the specific relief act, praying to grant temporary mandatory injunction against the OPs. Initially, the petitioner filed this petition against 13 number of OPs. During the pendency of the matter, this court, by its order dated 30/11/23, struck out the name of OP number 3, considering that OP number 3 died before the institution of the suit. After that, the petitioner, by filing a petition, prayed to strike out the name of OP number 5 to 15, claiming that the petitioner does not have any claim against them, and consequent to that, this court on 23/24 struck out the name of the pro forma OP number 5 to 15. Subsequently, upon concluding the argument presented by both the rival parties today, the matter is adjourned for order. The application in question pertains to a prayer for granting a temporary mandatory injunction. To understand the law related to it, we must consider section 39 of the Specific Relief Act 1963. This section deals with the grant of mandatory injunction, which can be determined based on two elements. What acts are necessary to prevent a breach of obligation, and B, the acts must be enforceable by the court. Case laws such as so and so, so and so, so and so provide guidance in this regard. Case 392, my lord. Injunction is an equitable relief, and equity acts in personam. Therefore, injunctions are personal matters. A mandatory injunction aims to restore a wrongful state of things to their former rightful order. The primary difference between the prohibitory and mandatory injunction is that in the former, the defendant is prohibited from doing a particular thing in a particular manner. In contrast, in the latter, the defendant is directed to do a particular thing, failing which the court can get it done through its officers. Case law such as so and so provides guidance in this regard. Mandatory injunctions should not be granted, A, where compensation in terms of money.
Mr. Bora, this principle is not required to be read out. You come to the this operative part of this order.
Yes, my lord. My lord, then para 14 is 395.
Yes.
In analyzing the legal context presented by the competing arguments of both parties, this court shall endeavor in its upcoming deliberation to determine the potential justification for issuing a temporary mandatory injunction based on the contentions put forth by the petitioner. The pivotal question at hand pertains to discerning if there exists a valid basis as elucidated within the petitioner's submission upon which the petitioner's entreaty could be deemed meritorious. The objective assessment of the material presented by the petitioner within the framework of a legal recourse shall guide the court in arriving at a judicious decision. The thorough evaluation of the arguments advanced by both sides against the backdrop of established legal principles and precedents is paramount in ensuring a just and equitable resolution. The forthcoming discourse will thus be crucial in elucidating the crux of the matter and determining the course of action to be undertaken by this esteemed court. Upon meticulous and careful examination of the detailed contentions provided by both opposing parties, this court has discerned that the petitioner initiated legal action seeking the declaration of rights, title, and interest in the Schedule B plot of land, as well as seeking confirmation of possession in the Schedule A plot of land, while excluding the Schedule D plot of land. The petitioner alleged that the Schedule D land was forcibly occupied by the opposite parties on 22/9/23, further requesting a permanent injunction to restrain the opposite parties and their affiliates from undertaking permanent constructions, alienating or creating any third-party interest over the Schedule D and Schedule A lands. Additionally, the petitioner sought the recovery of possession of the Schedule D plot. Well, this date is important, 22/9/23, because it is prior to the institution of the suit. A document is also there which is realized by the plaintiff, an FIR lodged by the wife of the plaintiff. 16. It has come to light that the petitioner has also filed an injunction application under case number 1000/23, with the court subsequently directing both the parties to maintain status quo pending a report from the circle officer. Following the submission of the report by the circle officer, the court is yet to issue any directives concerning the acceptance or dismissal of the report. Thereafter, during the ongoing miscase proceedings where the status quo order was issued, the petitioner has raised a new application for a temporary mandatory injunction citing the violation of the status quo order by the opposing parties. The petitioner alleges that the opposing parties have erected a concrete wall around the petitioner's buildings on the Schedule B land, obstructing the petitioner's right of way to their house, which has resulted in the blockage of the parked vehicles at the ground floor of the building. 18. The petitioner has raised concerns regarding the illegal construction of a concrete wall surrounding the building, which has obstructed the ingress and egress of 3 vehicles. The petitioner has also provided photographic document of the alleged construction. In light of these circumstances, the petitioner is requesting a mandatory injunction to have the structure removed and to restore the right of way for unrestricted movement. The right of way is crucial for the petitioners to access the building located on Schedule B land, which is a part of Schedule A land. The petitioner's plea underscores the significance of maintaining proper access to their property and the implications of the obstructive construction. Granting the requested injunction would not only address the immediate issue but also uphold the petitioner's right to unhindered movement on their property. It is essential to prioritize the resolution of this matter to ensure the petitioner's ability to utilize their property effectively and in accordance with legal provisions. The case at hand involves a significant dispute between the petitioner and the opposing parties concerning the alleged violation of a status quo order and the construction of a boundary wall on the petitioner's property. Throughout the legal proceeding, the counsel representing the OPs strongly opposed the petitioner's claim. The OP's legal representatives argued vehemently that the petitioner had misrepresented facts to the court by erroneously naming OP number 3 as a defendant, despite the individuals passing before the initiation of the lawsuit. Furthermore, the OPs contended that the petitioner's plea for equitable relief should not be considered as the petitioner failed to approach the court with clean hands, thus questioning the petitioner's credibility. The OPs specifically highlighted that the petitioner had deliberately concealed crucial information regarding the demise of OP number 3. This intricately woven legal battle delves into complex issues of misrepresentation, legal standing, and equitable relief, requiring a meticulous examination of the facts presented by both the parties to ascertain the just resolution of the matter at hand. In stark contrast to the opposite parties' stance, the counsel for the petitioner presented a compelling argument regarding the omitting of OP3's name from the petition. The petitioner, as per their legal representative, was unaware of the precise date of OP number 3's demise and consequently proceeded with striking out OP3's name from the file petition. The petitioner had initially included OP number 3 in the injunction application along with other OPs. However, it was brought to light at a later stage through the process server's report that OP number 3 had already passed away before commencement of the litigation. The legal counsel further emphasized that the petitioner had no knowledge of OP number 3's demise during the time of submitting the injunction application and initiating the current case. This unforeseen circumstance underscores the petitioner's position concerning the omission of OP number 3's name in the legal proceedings, highlighting the genuine lack of awareness regarding the said event. After carefully reviewing the arguments presented by both parties involved, the court has reached a conclusion regarding the petitioner's action in this legal matter. It has been determined that the petitioner did not have any malicious intent to deceive or mislead the court, nor did they possess any prior knowledge of the passing of OP number 3. The court emphasized that the petitioner consistently included OP number 3's name in all pertinent documents related to the case, such as the plaint, injunction application, application for mandatory injunction, and violation application. This was done inadvertently due to the petitioner's lack of awareness regarding OP number 3's demise. The court's finding indicate that the inclusion of OP number 3's name was not a deliberate act of misinformation, but rather a result of genuine lack of knowledge on the petitioner's part. As such, the court's ruling takes into account this important detail in the decision-making process. Based on the circumstances presented, it is determined that the death of OP number 3 was not a deliberate attempt to withhold essential information, given the court's explicit order to remove OP number 3 from the proceedings.
Moreover, OP number 3 was identified as a relative of OP number 1, 2, and 4, establishing a familial connection within the case. Thus, the court concluded that the petitioner had acted transparently by providing all pertinent details without any intent to conceal relevant facts. This finding underscores the importance of full disclosure in legal proceeding to uphold the principle of justice and fairness. By complying with the court directives and revealing the familial relationship of the involved parties, the petitioner demonstrated a commitment to honesty and integrity in the legal approach. This decision not only highlights the significance of presenting accurate and complete information to the court, but also reinforces the petitioner's credibility and adherence to ethical standards in the legal realm. The plaintiff has promptly filed an immediate application seeking a temporary mandatory injunction pertaining to the erection of a boundary wall encircling the specified Schedule B property, an integral part of the larger Schedule A property. The detailed photographic documents furnished by the petitioner unequivocally illustrates the completion of the boundary wall encompassing the structure, thereby causing obstruction in a manner that effectively bars access to the plaintiff's entryway. Moreover, the provided images distinctly reveal the presence of vehicles parked within the enclosed boundary situated beneath the reinforced concrete construction, all of which are owned by the petitioner. It is evident from the visual documentation that the aforesaid construction impedes the petitioner's right of way and uses of the property, culminating in an urgent plea for judicial intervention through the enforcement of the aforementioned injunction. The court has meticulously analyzed multiple aspects of the conflict involved, weighing the petitioner and the OP. One key contention put forth by the OP is that boundary in question was established prior to the commencement of the legal proceedings. This claim finds further validation in the testimony provided by the petitioner's wife during an interaction with the officer in charge of Jalukbari PS on the 24th of September 2023. In her statement, she acknowledged that the OP and a significant group of individuals, reportedly comprising 100 to 150 antisocial elements, obstructed the petitioner's rightful passage and proceeded to erect temporary structures on the vacant plot of land. Such statement not only strengthens the OP's argument regarding the pre-existence of the boundary, but also sheds light on the unlawful actions undertaken by the aforementioned parties, which have played a pivotal role in exacerbating the dispute at hand. Upon careful examination of the documents presented in the case, specifically focusing on FR and document number 29, page number 87 of the plain, the court has observed that the petitioner's wife did not make any claim regarding the construction of a permanent boundary wall surrounding his building on the date of 24/9/23. However, upon further scrutiny of the documents, particularly the photographs submitted during the injunction application in Miss Case number 1000/23, it became evident that the bamboo fence has been erected in front of the petitioner's building. Furthermore, the submitted photographs clearly indicate the presence of a concrete boundary that obstructs the petitioner's right of way. As the court proceeds with this matter, it will delve into the question of whether the opposing parties contravene the order to maintain the status quo throughout the trial proceedings. It is imperative to underscore that the burden of proving the alleged violation rests squarely upon the petitioner, who must substantiate his claims beyond any reasonable doubt. The court will meticulously evaluate all the evidence and arguments presented before reaching a final adjudication on this crucial issue. In addition, the court did not consider the Amin Commissioner's report for lacking clarification on the points raised by the petitioner. So this is the fate of the Amin Commission report, my lord. No cross-examination or hearing regarding the acceptance or rejection of the report occurred. Furthermore, the opposing parties' counsel argued that the petitioner failed to include the building in the schedule within the plain and that the prayer for mandatory injunction should be dismissed. However, upon examination, it was revealed that the petitioner did provide a description of the structure situated on the schedule land in the petition, making the OP's argument invalid. Ultimately, the court determined that granting the petitioner's request for the removal of the structure and the opening up of the right of way for vehicular movement would not equate to granting a decree for the recovery of a specific possession or a permanent injunction. This is because the land outlined in Schedule D does not consist entirely of a brick wall enclosing the petitioner's building. The petitioner alleged the breach of a status quo order and the construction of a brick wall on the disputed property. The court will independently decide on this violation based on the evidence provided by both the parties. During the course of argument, the learned counsel representing the opposite parties in the case made specific reference to various lawsuits, including suit number 726/23 and TS number 328/22. These suits involve defendant number 7 to 12 and the vendor of the present petitioner, as well as the pro forma defendant concerning the same dag and patta. The counsel highlighted discrepancies in the dispute dates mentioned in the objections and the injunction application, arguing that this inconsistency undermines the credibility of the petitioner's prayer. It is essential to note that the petitioner has presented various facts in both the plaint and injunction application regarding the alleged possession of the disputed property, both pre and post institution of the dispute. Given these circumstances, it is imperative for this court to conduct a comprehensive trial and assess the evidence thoroughly before adjudicating on the petitioner's claims. This approach ensures a fair and just consideration of the petitioner's contention in light of the complexities surrounding the case. In light of the ongoing dispute between the rival parties and the comprehensive document presented for consideration, the court, while refraining from delving into the intricacies of the current dispute, unequivocally recognizes the petitioner's entitlement to immediate access to their property. Right of way has egregiously hindered their entry into their own rightfully constructed residence, compelling him to seek temporary accommodation elsewhere. The contentions raised in the submissions and arguments put forth by the conflicting parties undeniably establish a compelling prima facie case in favor of the petitioner, warranting a thorough trial for resolution. The undeniable obstruction of the petitioner's access to their dwelling underscores the singular hardship endured solely by the petitioner, stemming from the purported installation of a concrete barrier hindering their right of way. The petitioner's case has clearly established that petitioner is experiencing significant inconveniences in accessing his own residence, thereby resulting in a severe injustice as he is unable to fully utilize his property. The issue of right title and interest over the entirety of the land in question will be thoroughly examined during the impending TS number so-and-so trial. However, prior to the trial, it is crucial to acknowledge that the petitioner is the one currently bearing the brunt of these inconveniences caused by the actions of the opposing parties. Consequently, the petitioner, compelled by prevailing circumstances, has initiated legal action by submitting the present application for the issuance of a temporary mandatory injunction. This injunction aims to compel the removal of structures such as boundary walls that are obstructing the petitioner's access to their property, thus ensuring their ability to freely ingress and egress without hindrance. Therefore, after careful consideration and thorough deliberation, this court has concluded that the petitioner is indeed facing significant inconveniences. If these inconveniences are allowed to persist for prolonged periods, it could result in irreparable harm and damages to the petitioner, as they currently have 3 vehicles within the boundaries of their property. This situation also poses a risk of potential damage to their valuable possessions. Consequently, the court has determined that all the necessary conditions for granting a temporary mandatory injunction are in favor of the petitioner. It is essential to issue a compulsory injunction to prevent any breach of the obligations of the opposing parties. This injunction requires the office to refrain from causing any disposition over the petitioner's right of way to his residence. Additionally, they must be compelled to remove the boundary wall from the front side of the petitioner's building. This action will enable the petitioner to have unobstructed access to their home and uphold their right of way effectively. Therefore, in the light of all the discussions above, this court is of the considered opinion that the petitioner is entitled to get an order of temporary mandatory injunction directing the office to remove the boundary wall from the front side of the building of the petitioner and open up the right of way for free movement of the petitioner through his vehicles for ingress and egress to his building extending over the Schedule B land, which is a part of Schedule A land. Accordingly, an order of temporary mandatory injunction is hereby passed, directing the office to remove the boundary wall from the front side of the building of the petitioner and open up the right of way for free movement of the petitioner through his vehicles for ingress and egress to his building, extending over the Schedule B, which is a part of Schedule A. Now, my lord, the Schedule B that is mentioned in the plain may be changed, the 4 side boundaries. That lordship will find plain.
Mr. Bora, we are not finally deciding the issue. You come to the points. What are the grounds?
My grounds, my lord.
Yes.
So my ground is that, my lord, as there is an allegation of injunction violation, and to that effect, an application under Order 39 Rule 3 is also filed, which has to be proved by the plaintiff petitioner beyond all reasonable doubt. And on the same facts of allegation, the mandatory injunction application is also filed. So by passing this order, it would amount to convict us in the injunction violation application also. It would amount to deciding the injunction violation application.
No, this is a different application under section 39.
Yes, it may be 39, my lord, specific relief, but on the same set of allegation. Whatever is stated here, it is also stated there. And secondly, my lord, my another ground is there that
you come to
in the
your
present-
application. You come to your application. Come to your points.
Yes, my lord. From page number 18, my grounds I have started.
Page number
18 of my memo of appeal.
Yes.
I have already read out the more or less the entire impugn order, my lord. But, my lord, the three golden principles of injunction jurisprudence, that is not discussed in the impugn order. So, ground D, I have stated that for that the three golden principles of injunction jurisprudence is not discussed in the impugn order.
Ground
And
number B.
my ground number D, A, B, C, D, my lord. In the present case, the learned trial court fails to show how the plaintiff has been successful in presenting a prima facie case for granting temporary mandatory injunction, and the same amounts to non-application of mine by the learned trial court to the facts that is presented by the parties to the case. And it is also a settled position of law that in absence of any prima facie case, injunction of any nature cannot be granted. And the learned trial court has completely ignored the settled principles of law regulating the grant or refusal of interlocutory injunction in the present case, which is highly illegal and not tenable and sustainable in law. Further, my lord, in the entire impugn order, what the case of the OP is projecting, it only confined to the date of the OP which we have raised a plea that the OP number 3 in that is the defendant number 3 in the suit, and the OP number 3 in the injunction violation, mandatory injunction in all other applications, she died prior to the institution of the suit. She died in the month of July. Suit was instituted in the month of October last year, my lord. And in all the applications, she is impeded. Now the question is how a dead person can come and can encroach.
It may not be in the knowledge of the plaintiff.
But my lord, question is he is asserting some facts in the injunction violation application also, in this mandatory injunction application also. If the person is already dead, how he can assert those facts against the dead person also? That is the pertinent question, which is not discussed by the learned trial court. And furthermore, my lord, there is a written argument we have
Mr.
placed.
Bora, learned trial court has devoted several paragraphs in respect of respondent number 3.
Yes, it is by that it has been justified. But the question is, my lord, what about those facts which are made against the OP number 3 also in the injunction violation? Because his case is that after passing the injunction order dated 6/10/2023, on 10/10/2023, we have done these things. That is his case in all the 3 applications. Now the question is, court is saying, learned trial court is saying that upon the report of the Jarikarak, it is come to the knowledge of the plaintiff also that she died prior to the institution of the suit, and that's why her name is struck out. But the pertinent question, in fact, the allegations that are made.
Forget about that defendant number 3.
Yes.
You come to other
Now, my lord, only the objection which the learned court is saying in the impugn order, that only to that aspect we are now fighting the case at the trial court, but not that, my lord, because we have filed the written argument also. The written argument, lordship, will find from page number from page number 309, annexure 9 to the memo of appeal. This is our written argument. We have given some headings, my lord. I'm not going out to read out the entire thing. My lord may be pleased to see page number 312.
Yes.
So here is a heading petitioner lied on oath. There is vague Amin Commission report, which the learned trial court also discarded, not accepted. Thereafter, suits pending for adjudication, page number 314. Suits pending for adjudication pertaining to the suit dag and patta and some portion of the suit dag and patta related to title suit number 619/23 and title suit number 726/23. So, prayer made by the pro forma defendant number 7, 9, 10, 11, and 12 as plaintiff in title suit number 726/23. That all the impleaded parties to the suit are not present in the proceeding, as because there are several. Thereafter also, admission regarding the date of closure of right of way prior to the institution of the suit, because there is an FIR relied by the plaintiff, that is the document number 21. It is also here also, my lord, page number 87 of the plaint, and there it is stated that the right of way has been obstructed. So now the question is, my lord, when there is a fact prior to the institution of the suit, there is a blockade. And to that extent, no relief has been sought by the plaintiff, my lord. Then, my lord, now he is seeking. So now order 2, rule 2 now comes into operation, my lord. Because he abandoned that part of his case. Although he was blocked, his passage was blocked, he was not seeking any relief, because I have already read out the prayers that is made by the plaintiff in the plaint. He sought declaration, confirmation of possession over one part, that is the civil B, and thereafter this recovery of possession, civil D. Now, how he acquired right over the civil B? Is there any explanation? How he got the civil D land, my lord? Now, the point is, my lord, why I am referring to the civil B, because the civil B, lordship will find that one side is bounded by national highway. And he is saying that we have blocked the front side. The building is facing towards the national highway. And there is no any blockade, my lord. And that is, in fact, was established while during the initial stages of moving the case. He has presented some photographs before Honorable Justice Budua, and those photographs also reveal that he can access the highway. But the point is, suppose this is the plot of land and this is the highway. Now he wants to move in this way through our land. So regarding this part of land,
No, you tell me when the boundary wall was constructed.
my lord, prior to the
Why-
institution of the suit. That is our case.
Prior to?
Prior to the institution of the suit.
Acha.
So because his wife is alleging that passage is blocked. Passage is blocked. Now the question is, my lord, as he has prayed, because why I press for this amendment application, because, my lord, I have taken a ground. In fact, I have taken a ground because this allowing of this application would amount to passing of the decree that is prayed in prayer number 3 of the existing plaint.
No, it is only for a temporary period. Temporary mandatory.
No, my lord, that is also not reflected. That is also ground I have taken. Where lordship will find it.
It is for a particular period.
No period is prescribed, my lord. No period is prescribed. That is one of our ground, my lord. Because it has to be passed for a certain period, not for an indefinite manner. It cannot be passed, my lord. And that's a ground we have taken, my lord. The lordship will find Z.
This is not an ex parte order.
No.
Both the parties were heard.
Both the parties. Both the parties, my lord. Lordship will find page number 20, our ground Z. Our ground Z, my lord. For that, the learned trial court has failed to exercise its jurisdiction so vested in it by passing the impugn order dated so and so, passing miss case number arising so and so, as because as per the requirement of section 37(1) of the Specific Relief Act 1963, temporary injunction is to continue until a specified time or until the further order of the court. But in the present case, there is no mention of any specified time, nor it is stated in the impugn order dated so and so that the order will be enforced until the further order of the court. Situated thus, by passing the said impugn order, the learned court has failed to exercise the jurisdiction so vested in it, which is illegal and prejudicial to the petitioners, as the learned trial court has directed the present petitioner to demolish the front portion of the boundary wall, which is our ancestral property. So we are admittedly, there is a dispute, my lord, not over this civil B. It is the civil D which he has described. His vendors, some other persons, the pro forma defendants, all have filed a suit claiming that land. We are claiming that land on the basis of one registered gift deed, which now he wants to put under silence by way of amendment. It is also here, my lord. And his vendors perhaps have also silenced by way of filing another suit. There is also one registered sale of the 1950s. Based upon that two documents, we are claiming the adjacent land over the same land. So we also have inherited, his vendors have also inherited, and the pro forma defendants, they are also claiming they have also inherited. So now the basic question is, my lord, the land which is now under our possession, our inherited land, why we will allow him to use that land for ingress and egress? Because his house, his land, purchased land, that is civil B land, lordship, the civil which he has mentioned in his claim, itself shows that one side is bounded by the national highway. You go through the national highway, who is he? Who is putting any sort of obstruction to him? But he is not going there. He wants to access, because this is the highway, he can go from this way, but no, he wants to go by this way, through our land, our ancestral inherited land. Why will he not?
Do you have any photographs of that plot of land?
My lord, his applications already there, my lord. Already on record, several photographs were placed before Lordship Devashish Barua. Honorable Justice Devashish Barua. At the time of hearing, this our IA application as well as this miss appeal. So interesting, my lord, I want to say, Lordship, prior to the passing of this order, 24/5/2024 order of the IA, the previous order may be seen now. That order is very much against us. On that day, the honorable court find that there is no any prima facie material to grant any status quo to stay order. On 17/5, I think, that order in the IA. But on the next day, this is the order passed. And because from the materials he placed, and what happened during the discourse at that point of time on 24 as well as on 17, he came to know about the defects of his case. Why he is actually not entitled to get this mandatory injunction order from that court. That's why subsequently in the month of June, he has filed this application for amendment also. Whatever is there, it is there in the amendment. And by amendment also, he now wants to, that I have already referred, my lord, there is a copy. He is saying that he has not prayed, but my lord, whatever he has written in 1, to add, incorporate in the prayer portion as prayer number 4B. What does it mean? He wants to pray something. That's why this document is important. And I pray for putting it on record, bringing it on record, my lord, for deciding the present appeal. These are all integrably related with each other.
No, presently we are against that injunction order.
Yes.
So we have to confine ourselves only to that order, that impugn order.
Yes, my lord.
So these are the matters to be dealt with by the trial court.
Yes. But the point is, my lord, Lordship is right. But when some amendment is sought in pleadings, it means the previous version that is already there is going to be changed. Something new or
No,
something
no,
modified version will
no,
be there.
that is not permissible, and the trial court will look after it.
No, no, no. Generally speaking,
Hmm.
certain portions were left out. Now we want to add this,
Hmm.
or we have mentioned this as this, but actually it should be this.
Mr. Bora, if it is necessary to determine the actual dispute, then an amendment can be permitted.
Yes.
And a trial court will
Yes,
look
that
into
the
it.
trial court will do.
Hmm.
But the point is, my lord,
Hmm.
when this
Uh,
order is
Mr.
filed,
Bora, maybe he is not an advocate.
no, my lord.
He is not an
No,
advocate.
no, 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 no.
No.
Previously, my lord, the name may be seen in this order which I am referring to.
Hmm.
His counsels appear. One Mrs. D.D. Burman, Mr. S. Sharma, Satyendra Sharma, lordship may know,
That's it.
brown color hair,
Hmm.
senior advocate.
May I
Now, for the last 2-3 occasions, he is appearing after passing of this order personally, and he is also personally appearing in the trial court also.
Hmm.
He can. There is no. I have no any objection. He can present personally.
No, no, no. He may present his case, but in respect of this drafting and this making pair in the plaint, there may be some.
No, no. Some other advocates were there.
Hmm.
At the time of moving the injunction application before the
Hmm.
trial court, when the order dated 16, this was passed,
Hmm.
and subsequently, while passing this mandatory injunction order also, Mr. Sharma, learned advocate, he was pursuing the matter there.
Acha.
And before Honorable Justice Devasis Buddha also, Sharma sir appeared.
Hmm.
So now he is personally coming. Now, what the point is, my lord, kindly see this amendment application.
Hmm.
So here, after
Acha,
the matter is left by Mr. Sharma, he has filed this application. But the pleadings,
No,
whatever
no,
is
Mr.
written,
Bora, let me know one thing from him. That do you have these photographs of your
Lordship, yes.
boundary?
Lordship, yes.
Can you
It is there in affidavit in opposition, Lordship, and page number. Number 500 and.
my lord, this one, annexer one, this affidavit. Satellite photograph, my lord.
Lordship, few points before showing the photographs, Lordship. May I clarify certain point, Lordship? Lordship has rightly stated that Lordship, when I was when they have taken the position of land, Lordship, I have to go from that point, Lordship. That on 18th of August
My
last
lord,
year.
my part is still not over. I have not submitted the grounds.
Then Lordship,
My part.
I will just clarify 2 points.
Okay, let him.
Okay.
Okay.
I will just clarify 2 points, Lordship. That is, first is, on my first counsel, I took 2 set of counsel, Lordship. Initially, I took 1 counsel when I was there in the hospital. I was arrested. I was with fake FIR and I was arrested. And then I was bedridden for many days. I was paralyzed literally because of this incident. So that time, one advocate I engaged over telephone. I have given him instruction, whatever required. And hurriedly, to save the property, he filed this petition, non-title suit. And of course, many facts were not highlighted, not brought before the Honorable Court. And then after something happened with that counsel, and finally I had to take out the brief. Then I explained everything before the Honorable Trial Court that I have come for justice because of something wrongdoing. Then Honorable Court has understood, and he in fact, Honorable Court has, I presented everything before the Honorable Court, and finally,
but the Honorable Court suggested me, you engaged some other counsel. In fact, he called up the previous counsel, he fired him in open court, and I had to take the brief from him. And second on after 2-3 occasions, I was advised that you engage some other counsel. I engaged Advocate Sarma sir. Then Sarma sir also, I don't know what happened to me. I cleared everything. I paid whatever he asked for. But finally, things happen like this. And before the Honorable Court of Justice Devassis Borwa, there also he could not perform literally. I was sitting nearby. I was sitting behind, in fact. Then Honorable Court asked me to clarify the facts. I had to come before the podium and I had to explain. On first day, second day also, he could not, I don't know why, he could not present not a single fact. And that is why somehow the Honorable Court has passed stay order. Then after, I took brief from him. I cleared everything, whatever his fee and everything. I have no enmity with him. None of the two counsel, two set of counsel. I have no grievance against them. It's my hard luck. Then I have decided, unknowingly or knowingly, it is my burden. I cannot engage I cannot take third risk. So that is why I am here, Lordship. And the temporary mandatory injunction, whatever stated, in temporary mandatory injunction, it is purely temporary. Lordship, it is temporary, purely temporary, as because it is a matter of ingress and egress. The basic right of a person. I have developed that ingress and egress. The Lordship, now I will come to the photograph. Since respected counsel has objected, I should not go to other grounds. Lordship, the land is like, that is the highway. And my plot of land about 15 feet below the highway level, Lordship. This highway is there. I'm here. And I had to construct a ramp over the Schedule D land. Photographs is there, Lordship. And satellite image also I have submitted. All for satellite images. Lordship, may kindly see.
Now you tell me, who is schedule? Your building is there.
My building is there in part of, it is in Schedule C and Schedule B and Schedule D. Building is not there in Schedule D. My ingress and egress is fall under Schedule D. Lordship, whatever stated that Schedule D adjacent to the national highway. Lordship, yes. Schedule D is adjacent to the national highway. But that Schedule D has been occupied by them. That is why I am nowhere. How can I go? Because land is not like rectangular or square. It is like zigzag. So that Schedule D land is touching the national highway. Lordship, I have given a drawing also, Lordship. You may kindly see. Satellite image also. So Schedule D is touching the national highway, and I have to climb to the highway over the Schedule D. I cannot climb other way. Lordship, that Schedule D, Schedule B, Schedule D is a part of Schedule B. That Schedule B entirely not touching the national highway. That is the problem. Had it been touching the national highway, and I have to build a road, specific road for that, and I have to climb Lordship, now I do not have any access. Lordship may kindly see the present satellite image, which I have submitted before the Honorable Court. Lordship may
Maybe, but
kindly-
this one.
Yes. It is sequentially from the bottom part, sequentially have annexed there. On the top, it is present situation. How they have occupied. Satellite image shows that till May 2023, even that time also my ingress and egress was there, and now the present satellite image which has been occupied by them. And Lordship, they are saying that their land is ancestral property.
So how this plot of land described in Schedule D?
Lordship, it is there in the photograph. I have shown the arrow mark that ran, and also satellite.
And to whom this plot of land belongs?
Which lot?
This Schedule D?
Schedule D, solely my Lordship, because Amin Commission report, has been now accepted. I have the certified copy of the Honorable Court's order, Lordship.
My lord, to my knowledge, there is no any order of acceptance because I have already shown that it is not taken into consideration.
Lordship, yes, he is right. He was right, but now I am right, Lordship. Lordship, may kindly see. I'll submit it, Lordship. The injunction application has been hold off. It is clearly stated, Lordship, that they are in possession of 1 bigha 16 lesser of land, and I am in possession of 3 kotha 4 lesser, I believe. It is clearly stated, Lordship. This is the recent 13th of this month. This order has been passed. And it is clearly stated, Lordship, as per Amin Commissioner report, the court has admitted that they have occupied 1 bigha, 16 lessa of land. And I am, despite of 1 bigha, I'm having only 3 kotha, I believe 4 lessa or something. I lost I misplaced my photograph now, or my photocopy.
Okay.
So Amin Commissioner has now accepted. Earlier they were not accepting. Rightly respected council has submitted. Earlier they were not neither dismissed not considered, because that point of time he has seen all the photograph, all drawing, submissions, their photograph, our photograph. Thorough discussion was a thorough argument was there. I was sitting behind of everybody them, so I was watching them. So they argued thoroughly, not once or many days. So finally, temporary mandatory injunction has been given to me. And Lordship, it is from my bottom of heart, I'm saying, although open court, I should not say such. I know, Lordship, wall is not going to be breaked, despite of honorable court's order. Because, Lordship, police high officials are behind of this land. When I procured this land, Lordship, I did not procure the land. I procured pitoni, pitoni, 20 feet deep with pitoni. I have photographs, all old photographs I have preserved. I procured that pitoni, developed up to this extent. Now, Lordship, that plot of land cost is more than 20 crore. Eyes are there, Lordship. That is why somehow land to be grabbed. That is why I'm not going to get this result that wall will break. I will get ingress and egress immediately. Honorable Lord.
Heard Mr. Beti Bada, learned counsel for the appellant, then Mr. Law Court,
BS Law Court.
counsel for the learned respondent in person. List the matter tomorrow.
My lord, beg to intervene. Can it be on Monday, my lord? If your lordship wish, then as the first item.
Lordship, on Monday.
On Monday.
Tomorrow,
because,
Lordship.
my lord, what actually happened, day before yesterday, my junior mentioned the matter. So he has not given his consent. Junior informed of this honorable court that he has intimated. Actually, one of my aunt has died. So today is the Shraddha ceremony. I have not attended. And tomorrow it is the Bhuj ceremony. I have to go to Jagiru. Even for this case, I have abandoned everything, my lord. And at the very last moment, I am saying so. Because my intention is to do this case, not to run away from this case. He is thinking that I am trying to run away or to drag this matter further and further, but that is not my intention. Today is the Shraddha day of one of my aunt, but due to the strict order passed on the last occasion, even today I am present here and I am pursuing this matter. But tomorrow it is our Bhuj ceremony. Can I be allowed to attend that event? So on Monday, if your lordship wish.
Mr. Bora, I have no problem. I don't have any problem. I can hear the matter on the Monday also. Yes,
Tomorrow
do you
my
have any
friend will file.
inconvenience?
Not Monday. If such situation, Wednesday.
Wednesday.
Wednesday
Yes,
has
Bora,
to-
Wednesday
My lord.
or Tuesday?
There is little possibility.
Wednesday is holiday, 2nd of
Yes.
October.
Because my lord, now I have to run with to several places of India for the admission of my elder daughter in private MBBS course. So the results are now coming tomorrow or day after tomorrow, thereafter where I have to run to UP or to Tripura. In these two places, I am trying to get admission. So this is the problem. So frankly, I am speaking, my lord. I don't know where I have to go, at what point of time. Last week also I visited Kolkata.
Tuesday may not be possible, Bora, on Monday.
Monday normally.
Yes,
I
my
don't
lord,
go out.
Monday.
Monday
I have no
normally
problem.
I
You
don't
have
go out.
problem.
I have problem. Also.
You have problem.
I don't go.
Then the only way out is we have to fix it after vacation.
Okay, lordship.
Fourth is closed.
4th is closed, so, but I have training program at Bhopal. I have to leave on 4th.
Oh. So let the matter may be kept as part. Then again, matter will come up before your lordship because already it is advanced a certain portion of argument. So if the matter is against some other bench, then I have to, my lord. So matter may be kept as part. It may be reflected in the cause list.
My best wishes to respected council's daughter. Similar situation with me. Of course, she is lucky. My son is not lucky. My son appeared from somewhere else. Same 10+2. But lordship, that is the destiny we have. But as on today also, we are suffering that way. I should not speak out everything. Lordship, next week, vacation is going to be started.
Vacation is from
7, I think. 6 or 7.
From 7. Just
From
before,
7th.
before 7th, Lordship. If
No, more থাকিব নোৱাৰিম আৰু। মোৰ ক'ত দৌৰিব লগা হয় থাকিলে মানে সেইটো মই
Why not 30th? Try on Monday.
কালি ৰাতিপুৱা আপুনি যদি যাব পাৰে বা 2 o'clock।
আজি শ্ৰাদ্ধ মই বাদ দি পেলাই ইয়াত বহি আছো আপোনাৰ এইটো কেছৰ
শ্ৰাদ্ধৰ পিছদিনা ভোজ
এইটোতো ভোজ হয়
শ্ৰাদ্ধৰ দুদিন পিছত ভোজ হয়।
দহা শ্ৰাদ্ধ ভোজ 3 দিন একেলগত আমাৰ নভাবিনো কেনেকে চলে।
If Monday it is not possible, then only we have to opt for this after vacation.
Yes, my lord. But matter may be kept as part.
Okay, no problem.
I want to pursue this matter before your lordship.
May be fixed, Lordship. Date may be fixed.
Yes, okay, we'll fix that date. 21, Kobe. October 21. The very first day of opening. 21st.
21st.
At 2 o'clock, Lordship, if possible.
Okay, okay.
Deeply on that.
Always.
List the matter as part. But I'm telling one thing to both the parties, that in case of granting mandatory injunction, the satisfaction of prima facie case must be higher than the ordinary injunction.
To that extent.
That is the principle.
Yes. It should be more than a prima facie case.
Lordship.
Order shows court is in
Whatever
confusion.
he is saying that his
Everything
land,
will be settled after
that
trial.
entire his land has been challenged in lower court as well as district or DC office. So as a revenue appeal, what happened? They shown some the deed in 1958 and 59 give deed. Never ever give deed. They gifted, but not accepted. And give deed, the donor was not the recorded possessor of this land because it was in
Not on the merit of the title. So that aspect has to be looked into by the trial court. Okay.
Now, since they are saying, I'm just apprising the honorable court because they're somehow showing that we are illegal. That is why I have every document. Whatever I will say, I will show it before your lordship. I rightly say I'm not a law student. I was not a law student. My profession is different. But I have to come before the Honorable Court, because my previous two occasions, I was suffered. I'm suffering now.
My lord, kindly the liberty that is given, that may be reflected into this order
Which one?
to file this, additional affidavit to bring on record the amended
In
petition.
fact, Lordship, that I have objection, Lordship, because amendment petition was just filed. It was not being objected by them. How can they object here verbally?
No, I'm not going to
Can
object.
they object?
Your
No,
admissions
Mr.
made, to bring
no.
your admissions made in the
That is-
amendment
that is-
petition.
that
That I
is-
need.
That is, let them Lordship argue that, object that before the honorable trial court.
Okay, Mr. Bora, you have produced it
Because
for
that
this
is-
court. I have looked into it. Not necessary further. I don't think that while testing the injunction order in this appeal,
But,
that is necessary.
but my
Lordship,
lord, the point
unnecessary,
is,
it will,
the submissions are somewhat different. He is today saying that the civil B land is a part of civil B land.
it is on the record.
But
Lordship,
in the
whatever they-
existing plan, no such statement is there. That statement is in the amended petition.
On that ground, they will argue, Lordship.
He is dragging the matter from here and there, and
Right,
lordship, it is quite difficult sometimes,
I-
Okay.
from where he is
Okay,
saying.
Lordship. Then they have.
Okay,
The next matter is 14 to 16.
Madam, you choose a date from him after
Okay.
vacation.
Get part heard, Your Lordship.
Part third.
Yes, Your Lordship. Because I just have traveled 60 to 70% was complete, so just few circulars were there to be issued, Your Lordship.
Okay, hard Miss Spencer, learned counsel for the appellant, then Madam
Actually, I'm Sharma for the
and
respondent.
Sharma, learned counsel for the respondents.
Yes, Lordship.
Respondents. Heard in part, list the matter as part heard.
Lordship, our date will be
Immediately
fixed.
after reopening of the vacation,
We-
we'll not fixing a
The
date.
date, Your Lordship.
Pardon?
On 21st
Part
November.
automatically
Maybe take
Since
it.
it is
Your Lordship.
part, the matter will automatically come.
No, since the matter is kept as part heard, it will be listed by the registry.
Listed.
Okay.
Huh?
Obliged, Your Lordship.